8. File an affidavit of every kind of people. We have
Item number?
8.
Okay.
Ready list for motion. Item number 1.
Please, my lords. Am I audible?
Yes.
Please, my lords. This is a application in the public interest, my lords. The petitioners had earlier approached the Supreme Court. We were permitted to withdraw from there and come before your lordships. My lords, this is the petitioners are the minority students union from the border tribal areas. This petition challenges the current action of what is called pushback of illegal immigrants by the state of Assam. It is our case, my lords, that there is nothing in law which warrants or which ratifies this action of what is called pushback. Pushback in law is irrelevant only in certain circumstances. That is, if there are aliens who are coming onto the territory and you catch them at the border and do not allow them to enter, where you have a no admission policy, that is pushback. But people who are already on this side of the border, who have been subject to judicial proceedings, and some of whom have failed in judicial proceedings, and others who are suspected to be illegal immigrants, there is no procedure in law under which they can just be taken to the border and pushed across the border. My lords, our prayers are at page 27. Prayer A requests that this court declare the pushback policy, which is adopted by the state respondent, as unconstitutional, illegal, and violative of Articles 14, 21, and 22.
Declared a policy.
My lords, there have been statements by the head of the government that there will be people who will be pushed back, that action is being taken to identify people who are liable to be pushed back, and there is nothing in terms of legislative or backing for this action. People are being just picked up from various areas, including the Bodo tribal areas. We have a list of about 16 people, which my learned friend Mr. Razak Bhuiya can hand over to your lordships. Balod's, there is no stated policy. There is no document. But as a matter of fact, this is what is happening. That people who are suspected of being illegal immigrants, or people who have had determinations against them that they are illegal immigrants, whose actions are possibly pending in the courts, or who have not had the means to challenge them.
There can be two categories. One,
yes, my lord. Yes, my lord.
One who has exhausted all the legal remedies.
Yes, my lords.
And one who has not availed any remedy.
Please, my lords. Please, my lords. And even among those who have exhausted all legal remedies, the Supreme Court has made a further distinction. The state relies on an order of the Supreme Court, which is at page 61, the order of Justice Oak on the 4th of February. My lords, there also, the Supreme Court made a distinction between people whose nationalities were not in doubt. There was a list of 63 people. My lords, may I show your lordships? I'm sorry. I think I've mentioned the wrong page number. This is internal page number 49, possibly.
Okay.
Written in blue. If you, no, I'm sorry. It is page 61.
61.
No, I'm sorry, it's 51.
at
It's
page
not
48.
61. It starts at page 48 and it is. May I read it, my lords?
Yes.
Today, one more the second paragraph. Today,
Yes.
one more affidavit dated 3rd February is filed, which is as vague as the earlier affidavits. We have perused Annexure 2 when we asked a question to the Chief Secretary, who's present through video conference, whether the nationality of the persons listed at serial numbers 1 to 63 is known. He answered affirmatively. As it is known that persons at serial numbers 1 to 63 are citizens of a particular country, there is no reason why the state of Assam cannot start procedure for their deportation. Even if address of these persons in the foreign country is not available, as the state is aware, they are citizens of a particular country, we direct the state to immediately start process of deportation in respect of persons at serial numbers 1 to 63. Then the order goes on to deal with other kinds of persons. Now, my lords, this list of 1 to 63 is also not available in the public domain. Under the garb of this list of 1 to 63, all kinds of people are being picked up. Now, the Supreme Court has also made it very clear. It wants the state of Assam to start a process of deportation. Now, my lords, deportation in international law also has a specific context. The state to whom the people are being deported has to agree to receive them. There has to be a legal process where the people who are marked for deportation have to be told that they are being deported to their home country and that the home country is receiving them. No procedure of any sort is being followed. People
To have the process of deportation with another country, whether there should be a treaty or agreement in place between the two countries?
No, my lords. As far as a treaty,
if I remember, there is no such agreement with the Bangladesh nation.
Please, my lords, your lordship is right that there is no agreement, there's no written agreement or treaty, but often these are also matters where beyond treaties also countries do accept. Now, if an Indian citizen were to unknowingly stray into a neighboring country, let's say Sri Lanka, and Sri Lanka decides to send them back, then we do accept it, even if we may not have a written treaty. Treaties become more relevant in another case of extradition. Supposing we want our citizen who has committed crimes.
What is the mechanism for deportation? What is the legal mechanism for deportation? Is it anything in place?
My lords, there are protocols, I am given to believe, between country and country. They may vary. It is the Foreign Office, the External Affairs, which corresponds with their counterparts in the receiving country, and people who are to be deported are deported.
Come to page 50. Come to page 50.
Please, my lords.
Second paragraph onwards.
Please, my lords. We direct the state of Assam. Is that the paragraph your lordship has in mind?
Yes.
We direct the state of Assam to initiate the process of deportation in cases of persons at serial numbers 1 to 63 within 2 weeks from today. We direct the state of Assam to submit NSE format in respect of persons numbers 267 to 270. Broadly, there are two categories of foreigners. One category is where the persons are declared as not Indian nationals and their nationality is known. That is 1 to 63. The other category is where the tribunal has declared that the persons are not Indian nationals.
Mr.
Egde.
Sanjay Hegre.
Yes,
Sanjay
Mr.
Hegde.
Hegre.
Please,
So there are two categories of foreigner. And
Of
one category is where the persons are declared as not Indian
Yes,
nationals and their nationality is known. So foreigners tribunal in Assam, when they render the opinion that they are not Indian nationals and they are found to be of post categories, post 1971 from the
Please, my lord.
specified territory.
Please,
This
my
is
lord,
the
may-
opinion
if I-
generally renders
Yes,
by the
if I
tribunal.
may,
Not
Yes,
Indian
if I may-
national and from specified territory. And specified territory is defined.
please, my lord.
Right.
Uh,
So
if,
this first category, one category, but the persons are declared as not Indian nationals and their nationality is known. This is one category.
Ye-
Is it not?
Please, my lord. Please, my lord. Please, my lord. If I may add a slight refinement to what your lordship stated. My lords, what the Foreigners Tribunal basically holds, and I've done quite a few of these matters from this state, my lords, is that the noticee is unable to prove that he is an Indian national, that he is not able to prove that he is linked to any person who is on a voters list prior to 1966 or prior to 1977.
And there is
1971.
another one from the
Please, my
specified
lord.
territory.
Your lordship is right. Your lordship has vaster experience in these matters. I have
No, I
not
have
come
no
across
experience,
many of
but
those.
I have seen specified
Please, madam.
territory means a particular territory.
Please, my lords, if there is proof before the tribunal that the noticee belonged to any other country, migrated after 1971, and his linkage to the other territory is proven, then yes, there could be that kind of finding also. But largely, proceedings which I have seen normally go to say that he is unable to prove, he or she is unable to prove their linkage.
Foreigners Tribunal.
Under the Foreigners Act, my lords, is your lordship, the
1960.
1940 Act, the Foreigners Order.
Foreigners Order.
Please, my lords.
Foreigners Order. Foreigners Order, Foreigners Tribunal, 143.
Okay. 1964, my lord.
Foreigners Order, 1964. Where does what specified territory is defined?
Lord, 6 is
Citizenship Act.
it has been defined in C.
Citizenship Act.
Citizenship.
6 is. It means when the territory is.
1 minute. 6A.
6A.
So tribunal at the same time,
Please, my lords.
I have seen orders that
Yes, my lord.
he is not an Indian citizen and he falls in the category of post 1971 scheme from the specified territory.
Please, my lord.
That is also the opinion.
Some opinions.
I have seen opinions.
Yes, my lords. Yes, my
So
lords.
if we revert
is
back to page
possible.
50,
Please, my lord.
there are two categories of foreigners. One category is where the
Yes.
persons are declared as not Indian nationals and their nationality is known.
Nationality
So
is known.
specified
So
territory,
three would be that. Would
specified
possibly be that.
territory is known. This category.
Please, my lord.
The other category is
Please,
where the tribunal has declared that the persons are not Indian nationals, but their nationality is not known.
Yes, my lord.
So if
Where-
the
where-
opinion is from the specified territory, there is a judicial, quasi-judicial view.
There's a
Thereafter,
quasi-
read petition. Thereafter, before the Honorable Supreme Court.
please,
Thereafter,
my lord.
that is the end of the remedy, legal remedy. So far that
Please,
person
Malay.
is concerned.
So far as that person is concerned,
Yes, specified
But
territory.
yes, but even to send him back to his specified territory,
Yes, no.
there would have to be a process of deportation.
Second category,
That-
sorry, they have to tell the court in what manner their cases will be dealt because they are neither Indian nationals nor in their citizenship status is known. We grant time of 1 month to file an affidavit. While filing the affidavit, Indian Revenue shall also place in record details of declare who are not Indian nationals and details of a person who has so far been deported. Details about the manner of deporting. Ultimately, whose task it is to deport? Central government?
Well, it is the central government. It is the central government, but the central government often delegates it to
Okay.
either the BSF
Okay.
or to the state authorities. So, my lords,
If I remember
Yes, my
correctly, there is a central
my lord.
government notification also how to deal with this matter regarding holding areas and all.
My lords,
I have seen one Justice Patiwala's order, Honorable Justice Patiwala's order.
please, my lords, I have, to be very candid with your lordships, I am in a vacation area and I've not had access to all my library.
Because
So,
this holding area concept has come from a
Please,
central
madam.
government notification. And
Please,
there
madam.
it is mentioned that this holding area concept is also applicable in case of Assam and persons declared as
Please, my lord.
not Indian citizen by the Foreigners Tribunal.
Please, my lord.
That is, do you have that order? Honorable Justice Patiwala's order, sitting in a division bench, a detailed notification about holding areas.
On the basis of, we have 3 holding areas in Assam now.
BSF and
Yes.
state government have been involved there.
One in Pokrajhar.
Because we have recently come across few habeas corpus petitions and we have found that they are kept in holding areas.
Absolutely. Earlier it was detention camp.
So at this stage, Mr. Hegre,
Please, my lord.
Mr. Mia, this is a registered organization,
No, my lord, this is a student organization.
not required to be a legal entity.
Not, they are working for the people, my lord, the grassroots level. Huh?
And why this National Human Rights Commission, Assam State?
Because, my lord, we made a representation before this, all other authorities. A formal party we have made, my lord.
They are themselves adjudicatory body. Why should we involve them in the process?
We can.
At this stage, Mr. Hegre,
Please, my lord. Please, my lord.
what are your prayers?
My prayers at page 27.
Page 27, my lord, starts at.
My lords, for the moment,
Any list of
BNC.
persons who have been deported already pushed back?
My
Any
lords,
list of persons?
My lord, that list is officially has not been published yet, my lord. How many persons has been pushed back? But in our BTC area, we have come to know, my lord, 16% has been picked up. And some of them has already.
Do you have their details?
My lord, we have their details, my lord, but off late, my lord, yesterday night we could collect, my lord. We'll bring it by an additional affidavit.
Because at least their credentials can
Yes, yes,
be
my lord, yes, yes.
looked into.
My lord, it is a fact, my lord, that the pushing back is going on and people are being picked up. In some of the cases, my lord, wherein, my lord, the cases are even pending before this honorable court as well as in the apex court. My lord, people are being picked up and at the gunpoint, they have been, my lord, compelled to cross the border, my lord. Such type of statement for the victims are also coming, my lord. as my lordship has already gone through the apex court order, my lord, in the second paragraph said that the deportation. Now, my lord, they can deport, my lord. We are not saying that the illegal migrants or illegal immigrants should stay in India. My lord, but the issue of, my lord, the human
Tell me
rights.
how deportation takes place.
Exactly, my lord. That is there is no policy as such. That's why, my lord, they are being taken.
So
My lord, they are being taken to
is there
the.
anything in place regarding deportation vis-a-vis Bangladesh nation?
As per our, my lord, information concerned, there is no any such treaty is available, my lord, with them. So therefore, my lord, there should be at least the humanitarian ground which are required to be followed. My lord, people are being taken to the border and pushed back to the no man's land area, my lord. That's the issue, my lord. A chaotic situation is going on, my lord, in the entire.
So after this order, whether central government has placed any affidavit?
No, my lord, as per
Huh?
our
No, my
information.
In
lord.
Rajubala
No,
Das?
man.
Yes, yes, no,
Because
no.
it is the Union of India.
Union of India, my lord. No,
Tell the
affidavit.
court in what manner their cases will be dealt
Exactly, my
with,
lord.
because they are neither Indian nationals nor their
My lord, as
citizenship
per
status is known.
our instruction is concerned, my lord, that affidavit is still not yet filed, my
We
lord. They
grant
have searched, my lord.
time of 1 month to Union of India to
Exactly.
file any affidavit.
We have not found,
My
my
lord.
lord.
So
We
it
have
is
make a search,
generally a subject
my lord.
to be dealt with Union of India, which can be delegated to the state.
State of Assam, my lord. Correctly.
Yes. Anything, Mr. Hegde?
My lords, just to, there is a draft UN legislation, proposed legislation, which is called by the International Law Commission, my lords. A copy of that might throw some light on the process, what a normal state is expected to do. Mr. Bhuya would hand it over on the expulsion of aliens. But just to be candid, my lords, this has not yet been adopted by the UN General Assembly. There is no
And,
convention yet. And as yet, but
something was submitted before the Honorable Supreme Court that India is not signatory to this.
no, this is not that convention. Once
Okay.
something becomes, this is just a recommendation by the
Draft.
International Law Commission.
Draft.
Has to be considered by the General Assembly. But your
Okay.
lordships can take this
First,
as a
we have
statement.
to learn
Yes.
that whether really pushback policy has been adopted in a
Absolutely,
legal
absolutely.
sense. And secondly, if it is
Please,
adopted,
my lord.
how it has been given effect to.
Exactly.
Right?
Please, my lord. So,
Yes.
there, my only statement is this. Pushback happens at the initial stage. Once somebody crosses the border, they become subject to the regime of the Indian Constitution and the Indian law. Similarly, your lordship, many of us have seen those videos of people at the US-Mexico border trying to jump over. If at that stage they are prohibited, admission is denied. Yes, that is pushback. But you cannot have pushback at a later stage. At a later stage, it is only deportation that applies. And deportation has to be on a government-to-government basis with the receiving government.
In anything in black and white, what is deportation legally?
Malutz, this particular statement by the International Law Commission shows some light on it. But please, Malutz.
Which para?
If your lordship use of terms, Article 2.
Article 2.
Expulsion means a formal act or conduct attributable to a state by which an alien is compelled to leave the territory of that state. It does not include extradition to another state, surrender to an international court or tribunal, or, and this is the crucial one to make my point, or the non-admission of an alien to a state. So then, my lords, the right of expulsion, the state has a right to expel an alien from its territory. It shall be in accordance with the draft articles without prejudice to the other applicable rules of international law. Then, my lords, the grounds of expulsion have to be stated. That's in Article 5. And at Article 8, sometimes if it ever comes into fruition, might have some instance. A state shall not make its national an alien by deprivation of nationality for the sole purpose of expelling him or her. And there is prohibition of collective expulsion. And there's also a prohibition of disguised expulsion. Article 10, sub-article 2.
Okay.
For the purposes of the present draft article, disguised expulsion means the forcible departure of an alien from a state resulting
But this is
indirectly
not,
from an...
not yet adopted.
No, this is not yet adopted. I'm only presenting it for its persuasive
Idea.
value as to a statement of what the international law position currently is. Because, as your lordship knows, international law is often called the vanishing point of jurisprudence. And we only open the textbooks and so-and-so said this, so-and-so said that. So this is the nearest I could get to formalization.
Let me hear the state for some
Please,
time.
my lord.
At this
Please,
stage, Lordship, I would not like to make any
Okay.
submission without having the complete instructions. But it appears prima facie that regarding the focus of the organization is filing, whether they can file this kind of petition or not, then they have to be examined, Lordship. So I am raising the issue of maintainability. We are not giving any individual specific particulars. I have gone through the petitions. Their statement says the recent drive against innocent individuals. Who are these innocent? This vague, innocuous statement will not help unless there is some specific.
That is why some specific instances should be there so that to proceed further anyway.
So let them supplement with proper particulars, then only Lordship may be
I
pleased
think-
to this or not. At this stage, in this vague petition, Lordship, they have not indicated what is the background of this pushback policy. They say that pushback policy should be set aside. So where is the? pushback?
Whoever has the legal remedies left,
My
so far as foreigners tribunal is concerned,
my lord.
if they have legal remedies, they can exhaust the legal remedies,
Exactly, my lord.
right?
Exactly.
And there may be an unidentified category of persons who may be subject to this alleged pushback policy. Could be.
Please, my lord.
No, my lord,
So
pushback.
if
My lord, the pushback policy which has been adopted by the state, my lord, is my lord, there is no any statutory prescription, provision, or even it has been supported by the order of the
so
court of
yeah,
law.
as
My
of
lord,
date, we
my
don't know. There is it is in the air, in the newspapers.
No, no, my lord.
Whether
that-
it is a
May-
yes, yes.
stated.
May I make a
Yeah.
submission? May I make a
It is a
submission?
stated policy of the state or not, we don't know as of date.
My lord.
Is there any pushback policy by the name or any other name,
My lord.
sending foreigners
Exactly, my lord.
without following any process?
Due process.
That would be responded to.
Exactly.
But
Exactly.
there are no identified persons
My lord, we have.
who have
stated-
been pushed back.
We have stated in paragraph 12, my lord.
Paragraph 12.
My lord, may kindly have a look, my lord. That, my lord, during the course of event, it is reported that the Assam Border Police arrested over 50 individuals from the various districts and transported them to the Matia detention camp in Gwalpara. They were later handed over to the Border Security Force or BSF, which forcibly pushed them into the no man's land along with the Mankachar border with Bangladesh, often during the night hours. Almost the persons who were pushed back was one Khairul Islam, a 51-year-old government.
Khairul Islam is in news.
My lord,
Okay.
my lord. In Assam,
He has come back, I think.
my lord, even we have annexed some of the habeas corpus
he-
petitions also, my lord.
That I know.
My lord. And Abu Bakr, Akbar Ali, my lord, we have stated the all.
So
the
far,
value-
Khairul Islam is concerned, okay.
No, my lord, in
This
paragraph,
we have learned.
my lord.
He has come back, I think.
My lord, he has been again allowed to come back and
Yes.
that is resident.
And any other,
Any other, my lord, in paragraph 16 also, paragraph 12 continuation, my lord. My lord, may kindly turn to page 16.
This too, yes,
thereafter-
my lord, this part, I remember that order of Honorable Justice Patiwala.
my lord, that regarding the holding area.
Yes, yes.
No, my lord, they can hold on. They can hold on, my lord, if there is a provision that some suspected person.
What is the result? After that, whereabouts are known or not of these two person?
My lord, that
After preferring habeas corpus?
Abu Bakr and Akbar Ali.
Yes.
So picked up, my lord.
Yes.
And now, my lord,
Did they file any habeas corpus, any habeas corpus
it is
petition?
not, it is not within my knowledge at this moment, my lord, but we have annexed.
Because
Some of the habeas corpus.
we
I
have
annexed.
dealt with
No,
also,
I have moved a petition before.
5,
my
6,
lord.
I have dealt with,
Yes, yes, my lord. Yes, my lord.
that whereabouts of the person should
Mal-
immediately be known.
should
Within 2
immediately-
days,
That is correct.
they have placed the instruction that this person is in this particular camp.
My lord. My lord.
So far as whereabouts,
Exactly, my lord.
right?
Whereabout is now.
Is there.
those
Then
mon-
after that point,
My lord.
it can be a case of pushback,
Exactly. my lord. Pushback
Right?
or deportation, my lord.
pushback for deportation.
My lord. Now, my lord, with all respect, my lord, what I humbly beg to submit, my lord, whether it is, my lord, it is an open fact, my lord, that the government of Assam has adopted the policy of pushing back those persons, my lord, more than 50, which we have come to know, and we have also a list. We have collected the list of the BTC area, those persons who had been picked up, my lord, the victims. Now, those lists, my lord, obviously, I will make a part of the record, my lord, by an additional affidavit, my lord. My lord, of whether the state of Assam has adopted any such policy of the pushback or not by, my lord, by enforcement with a law. My lord, that if come
Why
before my
have
lordship,
you placed that central government's notification,
my lord, that notification, I will make a search, my lord. I will make a
which has
search.
been extensively dealt by Honorable Justice
Pardiwala.
Pardiwala
Yes, my lord. I have also a little bit of. My
regarding
My
holding area, BSF,
That is
everything.
correct, my lord, holding area.
And
BSF.
there, the mechanism is also recorded.
No, my lord, but I don't think, my lord, that the mechanism allows them for the such an arbitrary
No,
pushback,
no.
my lord,
There are two distinctions.
My lord.
One is pushing back.
pushing back.
Now,
correct.
in the meantime, there is also holding area.
Holding area.
That concept is there
My lord,
fully. And you keep them in holding area until they are deported
that is the issue.
by
Even-
the legal process.
My lord, the Supreme Court has also directed the state of Assam. to
Supreme
go-
Court has also said
My lord,
India is not Dharamsala.
that is correct, my lord. We
Right.
are also.
We are not into it.
My lord,
We are into the exact legal procedure about the
Procedure.
deportation process.
pushback and deportation.
Pushback or deportation,
My
whatever.
lord. If
Deportation is legal term.
My lord,
Pushback may not be
legally
in legal
sustainable.
parlance.
My lord,
So you place those persons who have been pushed back,
exactly. my lord.
the details, then we can ask pointedly
my
that
lord,
they are missing.
My lord, even the
If
state.
they are on Indian soil
My lord,
on a particular date, thereafter, they have gone missing,
my lord.
meaning thereby they have been transported to the specified
My
territory.
lord, the media report is very much explicit.
Media report is
I
here.
know, my lord. It is very difficult to.
When I have held myself,
My lord, my lord.
media report is hearsay, not admissible in evidence.
That's why, my lord,
I am
even
not into
affidavit,
acting.
my lord, with all respect, my lord, what I humbly beg
You
to submit.
place all the
With-
details,
with
50
place.
persons names, they were on Indian soil, but they are as on date missing from Indian soil.
My lord, may I pray, my lord? I will make, that list is available. I will make a part
Please.
of that. Even the state is also the appropriate and best authority, my lord, that how many persons has been picked up and how many person has been pushed back. If the affidavit from the state comes, my lord, then it will be very, my lord,
Let us hear it.
mild.
The thing is that he wants to build up his case on my affidavit.
No.
If he is so socially conscious, he should do something more. That's why if any person is aggrieved, they are already before this honorable lord.
Please,
Just say.
at least
it
10
will have-
instances,
My lord.
then we'll ask.
Yes, my lord.
Lordship
we
has
We'll
already-
ask.
The habeas corpus petitions. So
Yes.
they have came.
No,
So that is why where this EIL is maintainable or not. If the persons are individually
May
aggrieved,
I-
they can file their individual writ petition.
So that 10, 15 persons were on Indian soil on a particular date. Thereafter, they have gone missing and they are not on Indian soil. Meaning thereby state machinery had acted. As a result, they have gone missing.
Exactly. We can,
right?
we can.
Then we can ask
May I-
immediately to the state where they have gone. Then
May
that
I make a
may be
suggestion?
the stage wherefrom we can proceed forward. So when you can file the affidavit, if you have the details,
Yes, yes, we have the details, my lord.
then we'll proceed further. Yes, sir.
My lord, you can affidavit comes from the state, my lord. My lord,
First, I have to satisfy myself.
my lord, my lord. Sir, want to say
May I
something?
may I make a submission, Madam?
It is up to you. 30 is there,
My lord.
30 and 10.
Yes,
Let
yes.
it come up on 22nd or 23rd.
After the vacation, we'll do, my lord. In the meantime, my lord, if they do not carry out the process of further,
No, those
pushback,
cases,
my lord,
those whose cases are pending in judicial forum,
my lord.
that, yes,
Yes, yes, my lord.
May,
I
There
don't
are
think,
5 categories, Lord.
Uh-huh.
And there are 5 categories of cases we have dealt with
Okay.
according to the law. If there is any pending cases where it is a stay order, nothing is being done. There are 3 categories where there is a opinion of the tribunal. They are foreigners and there is no pending appeals at any state forum, either High Court or Supreme Court. Those persons are being affected. And we are also resorting to the 1950s Foreigners Expulsion Act. So I'll come with complete submission, Lordship. I'll not do any submission on this basis. Let them make out their case, then we'll give the count.
so far as the cases of those persons
My lord,
whose proceedings are pending,
pending, my lord.
either before Foreigners Tribunal, High Court, or Honorable Supreme Court, they
Okay.
should not be touched.
They have
Right?
been touched, my lord. They have been
If,
touched.
if that is so, if
Well,
pending, proceedings are pending, I think they,
Now we are following due process of law, Lordship.
so far that
There
is,
a tendency.
that
No.
can be done.
My lord, no process of law has been.
My
followed,
lords,
my lord.
may
It has
may I
been
be heard?
up, my lord.
Yes, please.
When they enter India, there is
Yes,
follow the
please.
process of law. They visa.
Yes, please.
My lords, I'm
Without
sorry, I have a
passport, without
problem
visa,
because
they enter
I
India,
cannot say the court. My lords, I cannot see my learned friends who are arguing physically before your lordship. So therefore,
Okay.
okay. So, so
Okay.
my lords, your lordship is absolutely right that there are people who have cases pending before the courts. They are pursuing their cases, but there are, as your lordship, in your vast experience knows, there are also a lot of people who, for various reasons, cannot approach the courts or the tribunals or take things further. That is where courts have stepped in even earlier under their parents' patriae jurisdiction, as well as in the public interest, to see that no person goes away for want of justice or it becomes a victim of the process. So here, my lord may take it that just that Mr. Bhuiyan there has a list of about 15 or 16
That is what,
people whom he will
at
place-
least we should
who-
have something.
that will be placed on affidavit, maybe even in the course of the day if your lordship directs. But on the larger question, your lordship may ask for a written response from the state and an assurance from them that no person will be deported without process of law and without the central government be assuring this court that there is a receiving state at the end of it.
Let us see the
Because-
central government also, their response should be.
Yes, my lord. So, absolutely.
Because they have the policy.
At this stage, Lordship, let them make up their case.
Yes, first you
Because we
place
have
the
5 categories.
list. Yes, what are the
There are
categories?
categories, foreigners declared by Foreigners Tribunal, where writ petition and SLPs have been dismissed. So they are liable to be deported. 2, foreigners declared by Foreigners Tribunal, but no cases filed so far challenging the said opinion/order. This is second category. So they are also not having any legal protection. Third category, foreigners declared by Foreigners Tribunal, but released on the basis of common order of the Supreme Court after completion of 2 years of detention in center, even though there is no writ petitions or SLP pending. In some cases, they are appearing regularly in the concerned police station. There is a standing order of the Supreme Court at the time of COVID. So we have released, now we are going to move an application for removing that order also, because they were waiting for deportation in the detention camps. So they were released at that point of time in 2021. That judgment also, I think they have annexed in the proceedings. The fourth category, foreigners declared by Foreigners Tribunal and writ petitions or SLP pending in the High Court or in the Supreme Court, but there is no order of bail or not to deport. However, on the basis of common order of Supreme Court, they are released on bail under certain conditions. Accordingly, they are regularly appearing in the police station, complying the Supreme Court's order. So all these cases are not touched. First three categories, we are touching them. Fifth, declared foreigners where there are cases pending in the High Court or in the Supreme Court and there is specific bail orders and stay orders. So we are not touching them.
So where judicial proceedings are pending, you are not
We are
touching.
not touching.
So you observe.
So that is a standing order and that is a submission we have made before in Raju Bala's case also. All this is actually, these issues are already in session of the Honorable Supreme Court in Raju Bala's case, where the central government, we have filed for affidavits. I appeared on those cases.
Okay,
the second
this
case
case,
now
this order,
My lord.
which
Page
has been annexed.
Page 48.
This is Rajubala.
42, yes, my lord.
Yes, yes.
Page 48, my lord.
48. Okay, this is Rajubala. Okay, this is Rajubala.
My lord.
Okay.
Wherein affidavit is required to be filed by the central government, my lord. That is
Yes,
the status.
yes.
That has not yet been filed, my lord, as per our.
Central government is preparing it. Lord.
My
That is my instruction. Although I cannot make any
My
submission.
lord, the basic foundation of our PIL, my lord, is that regarding the pushback. Now, if the state of Assam has come up with a policy.
Mr. Bhuya, you
Mal-
place those 10, 15 names who have gone missing. On
Were
a bit.
affected by pushback.
Yes, yes, my lord.
So they have been missing
Right.
and that pushback policy have been enforced in their respect.
Yes. I
Then
can.
only we can ask. Then everything will be coming out of.
But my lord, state is also not denying, my lord, that they have not adopted to pushback also.
Let us
My-
see the stated policy.
Whatever we are doing, Lordship, it is as per law. Whatever we are doing. I am not saying pushback or no pushback.
I don't know, pushback and deportation are synonymous.
Because
I
the
don't
Supreme
think it is
Court has
synonymous.
gone behind us, because earlier we had only one option, that is to send back a person who is declared to be foreigner to the Foreigners Tribunal channel. The other channel is available in the 1950s order. That observation in the CA's case, Lord, 6A's case, it's a specific.
I'm sorry, my lord. My learned friend is not right. I've appeared in the
We'll
6A
argue.
case and I
We'll argue.
can place everything.
We'll
I-
argue when we come to the final stage.
Okay,
So,
Mr.
Yes.
The
Bhuya,
Supreme Court indicated us that we should follow
Yes.
1950s Act also. It was in
Uh,
cold storage.
I have not read that
Yes,
totally.
that
No, no,
2 pages order.
May I-
I'll give it.
Lord, another thing.
Frankly speaking,
Please
I have not
follow.
read that totally.
My lord,
The
and
Deputy Commissioner has
Paragraph,
forwarded
your
it.
lordship may mark paragraph 380. Paragraph 380 of the Supreme Court judgment. And there it specifically says, we may hasten to add that the reference is restricted to the limited constitutional validity of 6A. And the extent of the expulsion from Assam Act is not the subject matter of reference. Despite that, what the state relies on is in the operative portion, which says that the provisions of the Immigrants Expulsion from Assam Act shall also be read into 6A and shall be effectively employed. However, if your lordship goes to the 1950 Act itself, that Act is specific to say that you can ask people to leave Assam. That means they can still continue within India. And it also says that it shall not apply to any person who, on account of civil disturbance or fear of such disturbances in any area now forming part of Pakistan, has been displaced from or has left his place of residence in such area and who has subsequently been residing in Assam. So the very applicability of the Act, or if there is any specific order for instance, in these 15 cases that Mr. Bhuya complains of, if you say you have resorted to this Act, then there better be orders which say that I have examined it and therefore I am. Nothing of that kind is available on record.
Whatever 10, 15, whatever you have,
Mal.
50.
Yes.
You have 50.
Please.
My lord, we have reportedly come 50% has been picked
Okay,
up.
that is a
And,
big number.
my lord, now we have the record of 16%, my lord, with all details.
You place that.
Yes, yes.
When do you want to place?
My lord, immediately after the reopening, my lord, 16th or 17th, my lord.
It will
16.
come 1 week later, okay, I'll be there.
Sorry.
23rd or 24th.
My lord, till then, some protections for this.
Then let it come on 16th.
My lord. My lord.
No, what protection, Lordship? What protection they are asking?
We
now?
don't know identity.
That is why Lordship will not pass an order in the air.
No, no, my lord, we
They
are,
do not have the full particulars in the petition and they are seeking some protection.
my lord, we
This
have,
cannot be the process of a court.
no, no, my lord, we have
The Lordship will
specifically.
not pass an order in the air, which is a futile order, which is not implementable.
Court does not pass
Your
vague
Lordship will-
orders.
No, my lord, we are not saying on that, my
You
lord.
place
My
definite
respected advocate general. is-
identified
My lord,
individuals, then
My-
we can proceed further.
exactly.
So for the instances three you have given,
Yes, yes.
they are on Indian soil.
At this moment.
At this
but
moment,
they
right?
were taken for pushback and now again come back, my lord. Now whether that policy pushing back and again allowing come back, my lord.
And they have to come with another special thing, Lordship, that they are Indians. They have to have some materials to show that they are Indians. This law is not available to the foreigners.
No.
Heard Mr. S. Segril as senior counsel to the virtual mode, assisted by Mr. A.R. Vian,
My
learned counsel for the petition. And Mr. D. Hoikia, learned advocate some, assisted by Mr. B. Gogoi, and additional advocate some for the state respondents. So, Mr. Vian, learned counsel preparing for the petition, has submitted that he has received the detailed particulars of persons who
were picked up, my lord.
who have been picked up
My lord, for pushing
and
back.
and who have been subjected to the alleged pushback policy
My lord.
adopted by the state. Post of it is a submission that they were on Indian soil, but after being picked up, their whereabouts are not known.
My lord.
Full stop. He has sought to file an affidavit furnishing the details of those persons on by 14th,
14th.
13th, 14th, 14 is reopening.
Reopening.
File
My lord.
on or before 14th.
My submission is that I am trying to make this petition non-maintainable. Because if those persons are really in existence, they have a right and they have the means and with the relatives to approach this.
No, we are not
like
proceeding.
all the others.
We are
So-
not proceeding any.
Yes. So therefore, the issue of maintainability may be kept
Okay.
open and they will file it by 14. Lordship would list it on
Stick.
22nd. On 22nd, Lordship may be pleased to list it.
My lord, as my senior friend is insisting on 22nd, my lord, and I don't know what will happen, my lord. Still people are in a chaotic mood when they cannot sleep at night. Police is coming to the various peoples for picking up. They are not there in their residence, my lord. Now, my lord, although it is not a open on black and white that pushing back is going on.
But individually,
My lord,
their families, wherever they have approached,
my lord, my lord.
this court is trying to extend
Yes, yes, my lord.
whatever
That
possible relief
relief by
is there,
heaviest order.
right?
That is correct, my lord.
And even if after,
My lord,
say, opinion of the foreigners tribunal,
my lord.
they did not resort to the further remedy before the higher forum.
My lord.
With visitation right, they have been also provided the relief
That is correct.
with the to
No, my lord, that point.
that part. Individual cases are definitely looked into, but
Looked into.
here is a case which is
State-wise.
Very broad,
Very broad, my lord.
right?
Lordship.
That has to be
My lord.
carefully proceeded.
Because,
And on top of that, this is an unregistered organization.
my lord, that will satisfy, my lord. That
Okay.
will satisfy, my lord.
So
Lots
how
of,
can
lots of,
GIL
lots of judgments are there, my lord. My respected senior friend also
Sure.
knows, my lord. My
Okay.
lord, one thing is there, my lord.
You filed by 14.
By file by 14, my lord, in this petition, my lord, our main concept is that there should not be any policy of calling pushback. Pushing back cannot exist, my lord.
That is a
My
law, that is a issue, legal issue. to be
Legally, that
decided.
my lordship may be pleased to examine, my lord, because it has a
That
bearing.
can be examined later
Exactly.
on, not
Exactly, my lord.
today.
Exactly. That is correct, my lord. That is-
And policy is not before this court till now.
Now, whether that policy exists or not, that can be
No,
apprised, my lord. My lord.
agree on a date.
My
Please,
lord.
my lord.
Agree on a date,
On a
Mr. Hegre.
Sir,
My lord, sir, let them agree. I will attempt to be there. That's all
Okay.
I can say.
22nd, my lord.
Advocate General, Advocate General is suggesting 22nd. Let it be on
My lord,
22nd.
sign.
Okay.
I'm in your lord.
As agreed to by Mr. Whitehill, Advocate General has submitted, has raised an issue of maintainability of the instant PL. First of, as agreed to by the Land Council for the parties, release the case on 22nd July. You provide all the details.
My lord, well provided.
Highly obliged.
Oblige me.
Grateful, my lord.
Yes.
Great.
Item number 2.
Maybe.
Yes.
But this is similar cases are pending, my lord, before your
Similar cases pending.
pending notice is issued, my lord, and
Yes. Do you have any order?
yes, sir.
So you are joining the queue.
Yes, sir.
Okay. Yes, Mr.
More
Mudun.
of elongating the queue.
Huh?
More of elongating the queue. He was there, now he's elongating.
B. Procasto, Land Council for the. Right, Mr. B. Procasto, Land Council for the petitioners. Union of India, Miss A. Gayon, Land Central Government Council for the response number 1, 2, 3. Mr. R. Mujumdar, Land Standing Council, School Education Department. For the response number 4,
6.
6. Homogro Hikha? Anybody? And NCTE, Mr. Ayalamo. Homogro Hikha? Pinayak. Okay. And finance, Mr. H. Olihal and Standing Council Finance Department for the response number 5. Mr. Pinayak. He'll be as an additional advocate general or standing council?
Selling also.
Standing council. Homogro Hikha Mission. for the respondent number 7 and 8 and Mr. I along, non-standing counsel. NCTE for the respondent number 9. Full stop. Issue notice. Anything made returnable? Okay. As Mr. So-and-so appeared, accepted notice on so-and-so. No formal notice. Extra copies in requisite numbers are to be furnished to the land council paying for the respondents. The respondents are allowed to file their respective counters. List the case after 4 weeks along with WPC 5207 2024.
Obliged.
Item number 8.
Yeah.
Lordship, in this case, they have filed and government has filed an affidavit, Lordship. My prayer would be, your Lordship, let this matter come up immediately on after vacation, so the date already. There are two reasons.
The affidavit we have filed. Kindly keep it about 20 seconds.
Lordship.
As Botakur Land Council for the petition, Mr. D. Nat Lanet,
Affidavit is on record.
Lanet, Senior Government Advocate Assam for the state respondents are present. First of, the council for the parties have submitted that the affidavit filed on behalf of the state respondents has been brought on record today. First of, they have conjointly submitted that the matter be listed after the ensuing summer vacation. First of, list as agreed to, as sought for by the council for the party, list the case on 22nd.
Obliged.
For admission.
Should I record name? Advocate General? I have recorded his name.
My name will also be there.
D. Hoikia, Advocate General, listed by Mr. D.
You have given all the photographs, etc., and it has come on very nice. The constable.
I have not looked into it.
Will file.
22nd.
Lordship.
I know.
See. Okay,
Lordship, kindly list the matter for after vacation.
we are not listing the matter after vacation. I answer. Yes, your name, please.
Monica Das.
Vida, V,
M.
M. Heart, Miss M. Das. Learn it. Council. Appearing on behalf of Miss P.B. Bordelais, learned legal aid counsel for the appellant, accused appellant, and Miss S.H. Bora, learned additional public prosecutor. For the respondent number 1, State of Assam. This criminal appeal under section 415 Bharatiya Nagarik Puraksha Honita 2023 is preferred against a judgment dated 18/12/2024 and an order on sentence dated 21/12/2024 passed by the Court of Learned Special Judge Union Bracket POCSO at Golaghat in Special POCSO case number 43 of 2018, arising out of Tergaon Police Station case number 663 of 2017. By the judgment and the order on sentence, the accused appellant has been convicted for the offenses under section 307 IPC and section 376 IPC. Section 307 and section 376 of the Indian Penal Code and section 4 of POCSO Act. For the offense under section 4 POCSO Act, the accused appellant has been sentenced to undergo rigorous imprisonment for 15 years and to pay a fine of rupees 25,000, in default of payment of fine, to undergo simple imprisonment for another 3 months. Post of for the conviction under section 307, the accused applicant has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 15,000, which default stipulation. Post of conviction. The sentences are ordered to run consecutively. We have gone through the contents of the memorandum of criminal appeal. The criminal appeal is admitted for hearing. The case records of POCSO, special POCSO case number 43/2018. We call for issue notice returnable in 4 weeks. As Ms. Bora, learned additional public prosecutor, has declared and accepted notice on behalf of the respondent number 1, State of Assam. The issuance of formal notice to respondent number 1 is dispensed with. The accused appellant shall take steps for service of notice upon the respondent number 2 as informant in terms of the practice direction. The learned edition publication, public prosecutor is to obtain a report as the service of notice upon the respondent number 2 informant from the officer in charge of the Delgam police station to place the same on the returnable notice.
When this wrongly appeared, the mattress is supposed to appear in item number 3.
There is none, sorry, the learned legal aid counsel is found absent today on last week. But the name of Ms. P.B. Bordolo, learned legal aid counsel, is to be reflected in the appellant side record list.
Item 4.
There is no representation on behalf of the appellants to the on call. Let the case come for answer of justice be listed on a date immediately after the ensuing summer vacation.
Item number 5.
My lord, we agree by the order dated 26/2025 laws. The relevant portion is at page 221.
Where is that order?
Relevant portion at page 220 laws. And the operative portion at page 221 laws. The last line of the order laws. Was on 18/6, the matter came up before the learned single judge laws. On the day, on the prayer made by the 26 laws.
When is actually line number which to be. Now, why you approached the court?
No, Lordship, in fact, the action taken by the railway, Lordship.
What action?
No, railway is claiming that it is their land.
Right.
But in fact,
By what action they have taken?
they have issued notices, Lordship, orders.
Under what? 4-1?
5.
Four.
5.
5. Where is those?
I have annexed it. It is on page 182, 186, and 191.
So why you did not participate?
No, Lordship, in the year 2000.
You have the right to disprove. You have the right to
No,
disprove that in the proceeding before the estate officer that this land does not belong to you. So this notice is null and void.
In the year 2023, Lordship.
When this was? When this notice?
This is
2/6/2025. Very recent.
No, Lordship, the earlier notices are also there, Lordship. In the year 2023.
No, this is notice.
This is order, Lordship. This is vacation order.
Huh?
This is vacation order, Lordship.
Then this is, you participated in it.
Yes, Lordship,
Right.
2023.
Then
We,
there,
we have submitted our representation. We have submitted the documents.
right, this is an order.
This is an order, Lordship.
This is an appealable order.
Look, but the, when the action itself is unlawful, Lordship.
No, no, no.
And then
When there is an appeal,
Lordship,
appellate provision,
Learned Singh,
and not learned singers, I am holding now.
Lordship,
I have been holding it
Lordship.
repeatedly
Lordship,
because I am not holding it myself.
Lordship,
3 judges bench
Lordship.
of Supreme Court, Honorable Supreme Court, has held it repeatedly. 3 judges, not one. I think 3, 4 judgments.
Lordship.
This is an appealable order under section 9 or 11.
9, Lordship.
9, before the district judge. So no writ petition is maintainable.
Lordship, when the action.
No writ petition is maintainable. You exhaust the remedy under section 9. Thereafter, I have held. And because Honorable Supreme Court has held, no 226. Don't ever come in 226. It is only 227.
Lordship,
Don't take this route.
Lordship, our prayer before the revenue
We are,
department is pending, Lordship. Revenue department is pending. for
rightly vacated. Why it was not?
No, Lordship, our prayer for, we are in possession of the plots of lands more than 20 years, 17 years, Lordship. We
No,
have-
when
we-
there is an appealable order.
Lordship,
No
but
point.
when the notices
No
are.
point keeping it.
No, notices are issued, Lordship, at least during the pendency of the writ petition, Lordship. The status quo that was
No,
issued.
when it is not maintainable itself, how can an interim order be passed?
The notices were issued, Lordship. The notices were issued.
So interim order rightly vacated. You have the option.
Lordship, at least during the pendency of the writ petition,
No.
Lordship.
When writ petition is not maintainable, but the single judge has issued notice, I am not doing it because you have come before the this court,
Yes,
intra-court appeal against the vacation of the interim order.
Yes, yes.
So I'll not hold anything. If I observe something,
Lordship.
it would be to your detriment.
Yes, Lordship.
But to observe, I have to write.
Yes, Lordship.
I have to write.
Yes, Lordship.
Right from, I think, Nandini J. San, 3 judges bench, which has been followed. Yes, Miss Borderland. What are those? I have given many. I have given many. No 226, not maintainable. 227. Because it is a pre-existing authority in the appellate forum. He can go into all details.
Lordship.
And this is an order under section 5.
Yes, Lordship.
9,
Yeah.
thereafter 227. It is up to you. I have to pull. Yeah.
Lordship, then I'll not place this application.
It's up to you because I do
And
not want to
Maybe,
extinguish your endeavor before the last single judge. So make it.
we may be given liberty to exercise the remedies, Lordship.
Going before the single judge, you can do. I'll not
Lordship.
pass any observation to your detriment. That's, you find Nandini J. Shah, 3 judges bench, 2000, I think. Nandini J. Shah.
Lordship.
And thereafter, many others.
Yes.
Heard Mr. D. Das, learned counsel for the appellants. And Miss N. Bordelot, standing counsel, Revenue and Disaster Management Department, protestant number 1. Mr. S. S. Roy.
No, 3 and 4.
Learned Central Government Council for the response number 2, 3, and 4. Ms. Bora, you are for State Council. Ms. R.B. Bora, Learned Junior Government Booking. Assam, the response number 5 and 6. Also. Well, after hearing the Learned Council for the parties at some length, Mr. Das, Learned Council for the appellants, has submitted that appellants are not pressing this application and would be pursuing the writ petition pending before the Learned Single Judge. First of, in view of the above submission made by Mr. Das, this writ appeal stands close to on withdrawal. These are 2018, 15 SSC. 356. And one more, 9 judges, judicial orders. Okay. Appeal. Apply.
Supplementary list. Item number 9. Make please.
Yes.
Lordship, I have filed this writ appeal, Lordship, challenging the order of the single judge, Lordship. What has happened in this case, Lordship? There was the the appellants, we are working in a one-stop center called Sakhi, which is basically a central government organization and run by the NGOs initially, and now it is run by the departments, the district departments, Lordship, district administration, Lordship. Now, what has happened? We have been working till the month of March. From till March, we are working. In the month of March, they have issued an advertisement for all the posts which we are working on. The reason sought to be given is that we were initially appointed by an NGO. After taking over of the project from the NGO, the district administration has is seeking to remove us and then give an advertisement. But the irony is, Lordship, they have, without even removing us from services, they given us an advertisement. Lordship would see at page number 101. All these posts, Lordship, in all these posts, Lordship, we are working. Till date, we are working. 101 and 102, Lordship, these are the posts where we are working. But they have given it for advertisement.
Where is your appointment order?
But my order, Lordship, would find at page number 117.
Appointment order?
Yes, we have been appointed by an NGO. But that, because initially our appointment was not made by the district administration, because that time district administration was not even in the part of the scene only.
No, this is an NGO.
No, Lordship, what has happened? Central government has one-stop centers for women all across the country.
Let us see your status.
Lordship.
Central government may run the one-stop whatever. Who is this? Northeast.
Yes, there's an NGO.
NGO.
Yes.
Why it has come into picture?
Because the social welfare department used to run the one-stop centers through the NGOs. Now,
So it is given in contract
yes,
to this NGO
yes, Lordship.
by the central government
Yes, Lordship.
and
Not by the central government, by the social welfare department.
social welfare department.
Yes, Lordship.
Right. So this is the NGO, NEVARD.
Yes.
Okay. NEVARD has issued the appointment
Letters to us.
letters to you.
Yes.
So where is the involvement of the state machinery
Now, Lordship, in the year 9.
in this appointment?
Yes, I'm coming to that one.
No. Let us read this particular appointment.
Appointment letter.
Yes.
Yes, Lordship. Page number 117. The NAVAD is pleased to inform you that you are appointed for the post of IT staff, NAVAD, so Sakhi One Stop Center, with effect from 1/3/2020, 1/3/2019. Your appointment is temporary and contractual basis. The contract may be terminated upon 60 days notice of either sides. It is not an appointment of NAVAD, Sakhi One Stop Center or otherwise. It is a purely contract job. It does not therefore confer any right claim for continuation, regularization, absorption in NAVAD, Sakhi One Stop Center. The management will be at liberty to utilize your services in its integrated NAVAD Sakhi One Stop Center in any capacity and manner, keeping in view of your experience, qualification, and aptitude. Your monthly remuneration is as per project norms, budget subject to all statutory deductions like EPF, ESI, and TDS, etc. Your monthly remuneration salary will be transferred from NAVAD Sakhi One Stop Center to your bank account each month around the 10th of each month. But sometimes if the organization does not receive funds from the government in time, then your salary may got delayed. Lordship, these are all, Lordship, these are terms.
These are the most important terms.
Lordship, okay, Lordship.
I think these are the most important terms.
Lordship, Lordship.
Because to know your status.
Lordship. Your appointment will be subject to probationary period of 12 months. During this period, your services can be terminated without giving any notice or reasons. You may not go on leave without prior intimation approval from the management. Non-adherence to the rules can attract disciplinary action against you. You will serve a notice of 2 months for leaving your employment within the organization. If you fail to give 2 months notice, you will refund your 2 months salary to the organization. Your contract shall be subject.
So where is that NAVAD now?
That is what I was coming to, Lordship. Lordship, what has happened in the year 2022, the previous guidelines of the central government changed into Mission Shakti in the year 2022. After that, there was a period given till 31st March 2024. All the whatever one-stop centers or homes or whatever these were running should be integrated into the new scheme. That is Mission Shakti. Now, Lordship, that has not been done. I mean to say, in the process which has sought to be done, it was not done. Whatever it may be, in the month of October 2024, the contract of NAVAD got over.
NAVAD got over.
Contract with NAVAD got over with the Social Welfare Department. By that time, the state authorities, that means the district authorities, took over the one-stop center without following any process under the Mission Shakti guidelines. Because guidelines are there, as per the guideline, it should be taken over. And the period for integration was 31/4/2024. Now, that had not happened.
Now tell me, where is the privity of contract between you and the state?
No, that's what, because after it was taken over, we have been paid salary. Now, the Lordship may kindly see the salary slips.
No, privity of contract. Paying money is different thing.
No, Lordship, it page number 65. No, I'm coming to that, Lordship. Because.
No, we have no time today.
Lordship.
Right.
Lordship.
Otherwise, I could have heard you.
Lordship.
For day long, no issue. But you have to satisfy me. Today, I have burdened with many things.
Lordship. So.
Please don't come that way.
Lordship, in one-stop center, we are employees. We are employees of one-stop center only. And the government has taken over the one-stop center. Since they have taken over the one-stop center and they have been paying salary to us and we are working for them, Lordship.
Paying salary is another thing, privity of contract is another thing. Where is the privity of contract? The NAVAD gone. NAVAD is out of the scene. With that, your contract, you were under NAVAD only. You do not have a direct privity of contract with the state. Am I right? After NAVAD gone, you were paid salaries.
Yes, Lordship.
That is the crux of the thing.
Yes, Lordship.
Whether the privity of contract or the contract, anything, subsisted or not, legally.
Lordship, see.
Why you have come?
No, because, Lordship, this advertisement, Lordship, we are working in that post. Might not be that because this taken.
Why you have come before this?
Because I have challenged this order, Lordship, of the single judge. Lordship, I kindly see this, Lordship. What has happened during the time of motion hearing, Lordship, the court has, the single judge has passed an interim order Now that interim order has been wrongly given an effect to. Lordship may kindly see page number 155. It starts from Lordship. And the operative portion, Lordship would find at page number 158.
Appointed to.
158, Lordship may kindly see. Last portion, Lordship. After hearing the
Let
submission,
me read the hotel order.
Lordship.
180.
157, Lordship, that it starts. It appears that 8 petitioners were appointed in Sakhi One-Stop Center, Barpeta on contractual basis under Mission Shakti way back in the year 2019. And since then, accordingly, the petitioners have been rendering services. However, in the wake of advertisement dated 4/3/2025, issued by the Deputy Commissioner Barpeta, the petitioners had approached this court by filing the instant writ petition apprehending that the issuing that impugned advertisement notice, the respondents are seeking to replace the petitioners by engaging fresh Sakhi One-Stop Center on contractual basis. By referring to the individual appointment letters issued by the petitioners, the petitioner's counsel, Mr. Deka, submits that his clients are continuing to function as Sakhi One-Stop Center even till today. As per the terms and conditions of the agreement, the contract cannot be terminated without giving 60 days prior notice. As such, the petitioners cannot be replaced during the period of substitution of contract. It is submitted by Mr.
You have invited everything.
No, Lordship.
You have invited everything.
No, Lordship.
Is it not?
Lordship, that was not my submission. My submission was our contractual.
It cannot be now. It cannot be what has been recorded in black and white. Sir.
That is one leg of my submission. The other leg was that
And
our
court has
contractual
acted into it.
employees cannot be replaced by another set of contractual employees. Lordship, that is a
Ad hoc employees.
ad hoc employees. Lordship.
Question will be that when state machinery is involved and there is a privity of contract with the state.
Yes, Lordship.
But here is a case, there is absence of privity of contract.
If I may, Lordship, may I just read this?
We'll decide after petition. There is no privity of contract.
But I'll satisfy in that regard, Lordship, because Lordship,
there has to be.
the answer lies not in that, Lordship. Answer lies in the guidelines of Mission Shakti, Lordship. Because that is
The answer is with the appointment of the petitioners or appellants, not other actions.
No.
Because unless you establish your status, because you were contractual employees earlier, no doubt about it.
till today.
And it had a notice period from both sides. It cannot be one tal cannot make sound. It should be two tals,
Yes.
right?
Yes.
This way notice, that way notice. Now, tell me one proposition. You wanted to leave the job. You have got a
Better job.
very good job in America. Now, the state wants to retain you. Can the state, because it can also approach the court, can the state ask for a writ of mandamus or whatever? Such I want a writ to be issued to this person so that he should be retained in my organization. Can it be done? No, there is very two-way notice,
It
2
cannot be
months,
issued
both
to
sides.
individual, Lordship.
No, there is a law. You cannot force contractual employees. Contract specific to the contract. I'm not saying under the state or an instrumentality of the state. You were under never. You came into as a contractual employee under never. That's what do you call?
Roof.
Roof. Roof is gone. With the roof,
But I will satisfy on the next date, Lordship. But that
you
is.
satisfy.
But
Yes, you are. You are for whom? Okay.
All the petitions are pending.
Yes, Lord.
Action already there. I know, instead of keeping pending this.
No, today is the. Had it been yesterday, I could have. Not today.
Day before it was-
On the request of Mr. P. Deka, learn it. counsel for the appellants. Let the case be listed when we want.
Lordship, if after 17th, Lordship. I would-
17, 18,
18.
Mr. R. K. Bora, Learned, Additional Senior Government. Book. Some for the state respondents are please present.
I'll-
I'll come back after 5 minutes.
Tell.
King. Sing, no.
I can tell.
Sing perhaps. Wait, sim. Yeah, go to the sim. Similar previous, same and same date. A non-voto there, no? Same order. Speed data is there. Same order.
I don't want 11.
Yes.
May it please your lordship. My lord, the writ appellant school
What is the Indian order?
at page 14A, it starts
14A.
14A, and we agree with the observation, paragraph 14 at page 14F. My lord, the writ petitioner school, or writ appellant school rather, had filed the writ petition, assailing an approval given by the authorities on grounds ABC. We are not on that. During the proceedings on the motion day, an objection was taken by the other side for the respondent number 3, that the principal who's representing the writ petitioner school is a fraud. That surfaced as an objection on the motion. Thereafter, I was asked to produce some document. The principal was asked to produce some document to show that you were appointed. Accordingly, we have produced a document which was kept in the Honorable Court record and marked as Annexure X, by which we were appointed. This is not there in the petition record, it is kept there. That is 28th of June 2013 document.
Is there any mention here?
We had
In
indicated.
the order.
My lordships. There are 2 orders. Paragraph 6 at page 14D.
Paragraph
6 at 14D. May I read that?
14D.
14.
Yes.
The petitioner in the writ petition has claimed that he has been appointed as principal of the said school by the managing committee of Boroland Modern Tribal Education Society by letter of contractual engagement dated 28/6/13. The said letter dated 28/6/13 was made a part of the record and marked Annexure X. So when we were asked that the principal who's representing the school, is he a fraud? All on we could have on the motion, there was a document substantiating our engagement. Now, it so happened that the objection which came was on the footing that
Is it on the first day or some?
first day the objection came. First day we
Yes.
produced the document. First day direction was for an inquiry. The direction was put on the premise that
Yes,
my
there
lord,
is nothing to show.
that there's a society which is my lordships,
No, come to paragraph 8.
my lord.
This court had ordered it at 1360.
Absolutely, the first-
Where is that? Where is that order?
That Mr. Kapil. Anyways, be careful.
Not on the motion, first motion.
The first motion day, it was directed that they would conduct an inquiry. And on the second day, that report was placed before the court. And thereafter, the observation came at paragraph 14.
Make a preliminary inquiry.
My
with
lord.
regard to so and so.
My lordships,
When appointed by names Twitter, given in authority.
my lord.
They should have submitted an inquiry report. Where is that inquiry report 21/6?
Inquiry
My
report,
lord, we have handed over the inquiry report to them.
no, I'm coming to that.
That is.
I'm coming to that.
That is. not
No,
a
is
matter
it part of the writ,
No.
writ
No, 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 no.
appeal?
What
I
is,
am placing it. My lord,
my lordships, on the day when the inquiry report was placed on the court, before the honorable court, on that very day,
my lord, para 16 of the order, my lord. My lord.
1 minute, let him.
on 23rd of June 2025, I'm told the inquiry report was placed in this honorable court. And on that day itself, a copy was served upon us. And that day, this order was passed, giving us a chance to file an affidavit on 25th of
So it
July.
is a primary view of the court. Court can direct
Correct.
exercising 226 to
My
have the
lordships.
matter inquired.
Yes, yes, we're not on the inquiry.
Yes.
What we are on is that our stand to that report would have cleared up and would not have attracted the attention of this court, culminating in passing of this order at paragraph 14. Our stand would have been quite so very simple that I was
Where is the order of 13/6? Because there was some deliberation
yes, yes.
13/6.
No, this is okay. Copy to the 13.6. We don't visit it over. His objection was, if I recollect correctly, subject to correction, that the petition, the principal was not appointed by NESTS. NESTS stands for National Education Society for Tribal Students. That was the objection, that the principal was a person who was a fraud. He was not appointed by the National Education Society for Tribal Students. Our stand apparently would have been by way of an affidavit that NEST came into existence in 2019, where I was appointed in 2013. In the year 2013, the Boroland Society, which was there, was maintaining these schools. And thereafter, when NEST was created, NEST took over. So there was no occasion for me to have been appointed by NEST. These facts we could not even produce before the court, and the paragraph 14 observation came from it. That was the crux of the matter. If we are given one chance to file that affidavit, and thereafter paragraph 14 order operates, may not, subject to the conclusion, whatever is reached by this honorable court, my lord, at least we are heard on the matter.
Where is your appointment order?
My lord, that.
No, don't
No,
hand it over.
Correct, my lord. It was made a part of the record at Annexure X on the writ petition. I'm told that was not annexed. We had got the adequate photocopies. I stand corrected.
You could have annexed
Correct.
all this.
Since this was not filed by us by way of an affidavit, therefore we had copies which was marked as Annexure X in the writ petition, my lord.
Right. The reply is quite clear from National Education Society for Tribal
Absolutely.
Students.
That
Absolutely clear.
our submission,
Everything is murky.
my lord, my submission at this stage, with all respect, would be, I was appointed on 28th June 2013 when NEST was not even formed. NEST
Then
was
is that, let us have the privilege of looking at your
appointment. Good.
part of the document.
This was not a part of the record of the writ petition also. This
You
was
could
made
have brought it. for
correct.
the-
We should have.
Could have brought
We
it.
should have.
That you
We
throw
will-
the document across the board.
The way it was filed.
And
Correct.
first order also should have
Should
been, should have been,
Should have been.
and not,
That was there. Our sole contention, my lord, is that
court has not reached the primacy observation on one day.
absolute.
Court has reached
Correct.
that primacy observation after deliberation,
My lord,
after getting report. At least we have,
Correct.
at least
But-
the two answers given by the
What-
National Education Society for Tribal Students.
what I am
So
on,
everything is murky.
no, what I am on, with all respect, my lord.
Huh?
What I'm on with all respect, my lord. The question which formulates or which becomes apparent is whether nests, in short, have appointed the principal. Yes or no would be an answer.
The court has a
But-
doubt, court
By
can
the way-
have the.
Correct. What we
Right.
are on, I am not at all on two words on that. What I'm on is that my document before this honorable court is of the year 2013. And I am appointed by a different organization.
Court has
Eh?
not disturbed your appointment, so-called appointment.
Nest was born in 2019, his national website is there. Nest was not born when I was appointed. That is my case. Therefore, no amount of inquiry would substantiate my appointed my Nest because we cannot time travel. 2013, I
Let
was
the inquiry complete.
this observation to register a case against me without affording an opportunity to me
When,
to reply. Well, let
when
me
the
reply to
court-
that.
When the court, it is not that you have been, what is the law in criminal jurisprudence? You are presumed to be innocent.
The paragraph 14, my lord, as it reads. if I may-
No, prima facie.
Prima facie, my lordship would kindly consider this submission of mine that Nest was formed in the year 2019. An Annexure X document taken in record substantiates my appointment in 2013. I could never have been appointed by Nest. They subsequently took over all these Vidyalayas, my lord. So I was not appointed by Nest, my lord. That is my case all along.
This Boroland also,
They appointed me. We stand by that. Subsequently, Nest was formed in 19 and that was taken
No.
over.
who has established the school?
School. School is formed by the
Please show me
ministry.
the document.
School is formed by the ministry. Under the ministries, these schools are formed
Where
for
is the-
development.
How it came into
My
being?
lord,
Please.
so far as two documents which we have is that one, these two documents would suffice.
How you have entered into the scene?
I was entered into the scheme because the schools are formed under the ministry's things of 97, 98. Thereafter, this comes in.
This Boroland Society,
Yes.
Model Education Society is.
There were two, my lord, if I may say, there were two
Everything
guidelines,
is
one in
party.
2010, one in 2020. Before the Nest was born, these were organized under the guidelines by NGOs, etc., for the welfare of the ST students of the community of the area. Subsequently, when Nest was formed, things were organized and Nest took over. These documents which we have are suffice to show how the taking over took place so far as this is concerned. ma'am.
Everything will be, you participate in the inquiry.
You know, this setting up of a case against me, my lord, of
No, no,
cheating.
no.
The observation of paragraph 14, one reply from me, the honorable single judge considers and then passes the paragraph 14 order. Still, I have a say. I have nothing to say before the honorable single judge, my lord. On the same day, the document, the inquiry report was submitted the
These are
same day.
privacy observation. Court has directed the investigating
True.
authority to.
What I am on is that the direction is whether X appointed me. X was not even born when I was appointed. The society was not even born.
Disputed questions of fact, all these are.
Constitution of fact. Nest was born in 2019.
Okay.
My-
Argo, the other cases will
Nothing
not
is,
be
that is it.
taken up.
That is. That's it. But I am only for right of reply. One day, one reply, and the next day taken up. 14 we submit the reply, 15 the case is taken up. That's all.
Court did not reach any privacy suspicion about your credential.
I leave it to your
Hmm.
lordship. Only 14, on 14th I file the reply and 15 the matter is taken up. That much, my lord. And 15 of paragraph 14 resurfaces after consideration of my reply. That much I pay. Nothing more.
Apparently appears to be privacy case of cheating unauthorized.
That much I pay. Nothing more.
So you participate in an inquiry?
Will participate.
Establish your
Only my
credential.
right to reply before this paragraph 14 takes place, my lord, takes effect. That much.
Well, you should notice at this stage. We don't find anything that substantially you can have established privacy. Because this is Boroland Society is also doubtful.
So would my lord be pleased to post this appeal on the reopening in the even we'll put the factual stand of ours before for consideration.
Yes,
my
you
lord.
place all the documents on record at least to
Absolutely.
examine.
But since this was no right was given to us.
Because otherwise this will be extraneous.
Correct. So lordship posts the matter, kindly post the matter on 14. We file an affidavit 15. We file an affidavit on these grounds. And
Today it is very difficult to examine all these issues.
I understand. I understand. Would my lord be pleased to protect me till 14, my lord,
What?
from paragraph 14?
Any cases registered?
No, I don't think so, Mr.
My lord, I can
Any-
find out. I can
You
just.
find out
Then the police
Please
would
find
just take me, my lord. Then the arrest part comes. my lord.
that.
Then observation comes in, my lord. Without my right.
No,
of-
inevitably it is difficult, sir.
I'm not praying for a bail. What I'm praying with all humility is that this paragraph 14, if lordship so considers that I have a.
No, I am not.
strong-
After consideration, I have found not to
Then,
disturb at this stage.
then let the writ appeal be taken up on the reopening day, 15th. We'll
15th.
submit it on 14th.
Okay.
Ask them to the inquiry report.
Offices are open. You can file it. We can post it on 14.
Lordship posted 14 for consideration of interim payment.
Let us have the
Sure,
Mr.
certainly.
Thorpe, any cases
In
registered?
between, if I'm arrested,
Any
my lord,
idea?
everything goes.
Yes, madam. I can give the number.
Give the number first.
Then
In
No,
fact,
give the number first so that to miss the money.
in
at
five
least-
minutes,
You can help Mr. Bonit out,
In the
Bonit out
meanwhile-
on that
In
aspect.
the meanwhile, my lord, even if I'm taking it out, even if I find an application for anticipatory bill, my lord, these things come in the way, the observation
May
comes
not,
in
may
the way.
not, may not. These are documentary things.
But this may come into it.
This-
Therefore,
this-
that particular.
I'll not observe anything, Mr. Bonik. Just I'll help you to
Correct.
get
Not-
the case number so that you have all the legal remedies before you, right? Otherwise, you
Fine.
may find difficulty in getting the number also. Mr.
I'll in 5 minutes. come.
Okay. Then we'll take up after some time so that
Not sure. Can be incorporated.
you can get the information. Okay. Heard Mr. S. Bonik, Learned Counsel for the petitioner, appellant, and Ms. Ardhor. You were appearing for whom, Mr. Tribal Affairs? Mr. Bhattacharya, you were P.S. Bhattacharya, Learned Central Government Council for the respondent number 1.
10.
One.
10 also.
Mr. Bhattacharya, you are for whom? Please, 1. Mr. Dhor, Standing Council, Ardhor, the Tribal Affairs Plain Department. 2, 3, sorry, 3, 4.
3, 4.
Not 5. Miss R.V. Bora, Standing Council,
And 6, 10.
6, 7, 8.
Just come, my lord. 11 of 24.
6, 7, 8.
Yes, ID, yes, case number.
And state, or Mr. R. S. Bora, and it's Junior Government, some for the respondent, number 10 and 11 post. Mr. Bonik have submitted that he will, the appellant, the appellant would submit additional pleadings in this appeal, which are required to be brought on record for the purpose of effective adjudication of the writ appeal. So, as sought for by Mr. Bonik, released the appeal on 14th.
14.
File it in the office.
My lord, just come.
Give the information to Mr. Bonik.
Case number, my lord,
Note it
11
down.
of 25 under section 61 to
Wait for me. Last.
And police station,
police CID PSP.
offenses,
Yes, ma'am. Under section 61 to we are 19 U and we are 18 4 PNS.
I'm not familiar with PNS, okay. Something like 415 kind of thing.
Yes. Item number 12.
My lord, an order of a honorable learned single judge dated 26/25 is under challenge, my lord. The basic contention, my lord, of the writ petitioner, my lord, before the learned single judge was regarding holding the charge of the post of headmaster of an upper primary school, my lord. My lord, a very serious disputed question of facts, my lord, had been gone into by the learned single judge and decided against me, and the by order by which, my lord, I had been provided the charge had been interfered with, along with the, my lord, the seniority list which had been prepared, as well as, my lord, there is a direction that he should be allowed, the private, the caveator and the writ petitioner should be allowed to hold the charge of the headmaster after setting aside of mine, my lord. So that order is under challenge in this petition, my lord. A very extensive and a very elaborate judgment is there, my lord. I think, my lord, it will take some time, my lord, to satisfy my lordships, my lord.
Yes. Many, there is a judgment.
The judgment, my lord, may be pleased to find, starts at page 217.
What is the position now?
Position, my lord, till date charge handing over has not taken place, still I am.
Yes,
holding-
Mr. Majumdar. We are running short of time. You are for whom?
But I will put the caveat.
Caveat.
Yes.
Yes.
Writ petition.
Yes, what is the law
Well, the,
Adjudicated, issue adjudicated.
well, the matter is
Hmm.
very clear, but there is no disputed question of fact, well, as my minute has been stated, well,
The appellant is what? Teacher. Both are
Yes.
teacher.
Both
Yes.
are the teachers of the same
Appellant,
school.
appellant is
Hindi teacher, my lord.
in the teacher and NDBC.
BSc teacher.
BSc teachers from the same school.
Same
Same.
school,
Okay,
And both are joined on the same day.
same day.
same date.
Same.
Yes.
Okay,
And date of birth, my date of birth is prior to his date of birth.
No, my
And
lord,
4 years-
by
4 years older than-
age, my lord, I cannot dispute. By age, he is senior, but the dispute arises the time of joining, me.
No, but
The time of joining, which has been shown by the caveator, my lord, is 9:45 AM in the morning when school never opens, my lord, which is always 10 AM.
shall I hold something?
My lord. can-
9:45 to 1 o'clock, 2 o'clock on a
Right.
day?
My,
Huh?
no, my lord can.
That,
hold.
that
My lord can.
does not hold any water.
My lord. And other issues are also there, transfers. my
Other
lord.
issues may be.
My lord, the transfer which has been taken by the
If the
caveator.
Same day appointee,
My lord,
same.
if there is no merit list,
My lord.
they come from different categories.
That is correct.
Then in case it will be the age,
My lord. So my
right?
lord,
Or there was any valid appointment process as per the rules.
correct.
But same day appointee from different streams,
Well.
Hindi and Science. Same day, join same day.
My lord. But the,
The timing would not matter.
my lord, and
In that case, it
if
is.
I cannot satisfy.
No law, no rule has said that
Time.
time would matter.
No, my lord, in that aspect of the matter, my lord. what
In
my
case suppose there is a big,
Judgment.
suppose 5,000 appointee in teacher,
My lord.
everybody will come at join 9 at 10 a.m. If
That-
that
that
gets the
must-
seniority, no.
Mass joining is a different issue, but
No,
here is an
even
issue.
in two also,
My lord,
even in two, same.
my lord. So my lord can
That
hear
is
it.
the only issue, my lord.
No, no.
Both
That is,
processes
that is
are
not
met.
the only issue, my lord. Other issues are also there, my lord. The other issues.
If he is
which the-
apparently senior,
My lord,
Yes,
they-
same day appointee,
Yes.
no, my lord, the transfer which he
Will-
had obtained, my lord, in his own request, my lord,
No,
that
but
has
that's-
also,
we will not deliver today.
my lord,
Yes.
my lord,
I think better
my lord,
for both of you.
Yes.
my
my
lord.
Yes.
Here, here. What happened? R. Mazumdar. Standing counsel. School education. 1, 2, 3, 4. And Mr. R. Islam. Learned counsel has entered appearance for, who has entered appearance for the caveator stroke respondent number
Right.
5.
Yes.
Post. The appeal, writ appeal will be listed on 14 or 15?
15.
15? 15. Yes, what by the parties.
Can I pray for an status quo as on today? Status quo till 14th.
No, my lord, that.
It will be difficult.
Yes,
You hold
Because he hold the post.
I am
Ye-
holding, my lord. Till now I am holding.
No,
heavy call.
much of that.
Highly obliged, my lord. Highly obliged.
Item 13.
May I please, Your Lordship?
Yes.
My Lord, having regard to the paucity of judicial time, I would be very much precise, my Lord. In fact, what has happened, the appellants, my Lord, they are 5 in numbers, as well as the private respondents, my Lord, 5 to 10. We have served copy, my Lord, to the caveator. And the private respondents, 5 to 10, both are, my Lord, the elected members, my Lord, of the Lanka Municipal Board. Now, your Lordship is aware that in terms of the Assam Municipal Act 1956, there are 2 categories, my Lord, of members, one elected members and the others, my Lord, ex officio members. Section 11(3) says that the MLAs and MPs who represent, my Lord, the constituencies, parliamentary constituencies, as well as the LAC, my Lord, which partly or, my Lord, fully comprises the municipal area, they are the, my Lord, ex officio members. So having regard to 11(3), my Lord, before the delimitation exercise carried out in 23, which your lordship has held, my lord, that will come into force, and it has also come into force, there were 14 members, including ex-officer members. Now, pursuant to the delimitation, my lord, one LAC is excluded, or rather, the municipal area is excluded, my lord, from Bhujai. Thereby, only Lamding remains. And therefore, the composition changes, my lord. From 14, my lord, it's reduced to 13. And another aspect of the matter,
Ward commission,
ward commissioner, my lord, ex-officio member,
it has changed.
changed, my lord. The composition of the, my lord,
Mm.
board
That
has-
is by law.
Yes, by law, it has changed, my lord. And earlier, before the delimitation exercise, my lord, it was the Nagaon constituency, which comprised, my lord, the municipal area. Now it is Kaziranga. Therefore, the MP,
No, we are on which board? Municipal board.
Lanka Municipal Board, my lord.
Lanka Municipal Board. Lanka is, you want to say LAC areas.
LSC and parliamentary.
LAC areas of Nagaon constituency.
No,
No,
earlier, what I'm trying to say,
no.
Yeah.
Otherwise, Nagaon town is at a distance from Lanka.
Hmm.
Nagaon
Yeah.
town is at a distance from Lanka.
yes.
You are Lanka.
Lanka, my lord.
Lanka. Nagaon Municipal Board has a different entity. Lanka is different
No, no.
since earlier.
Yes, no.
Now, what you are trying to,
I'm trying to say that before the delimitation exercise, the Bhujai LSC, as well as the Lamding LSC, that comprised, my lord, the municipal area. So therefore, both the MLAs were, my lord, the ex-officio members of the Lanka Municipal Board before the delimitation exercise. Now, pursuant thereto, my lord, Bhujai has been excluded. Only Lamding comprises, my lord, the municipal area. LSC, Lamding LSC, it comprises the municipal area.
within Lamding LAC, the municipal, Lanka Municipal Board areas
Right.
are.
And now presently, after
That is what you want to
Yes,
say.
precisely, my lord.
Within
I am unable to put across, my-
Lamding LAC
Yes,
areas,
yes.
this municipal board areas falls.
Yes,
That is what you want to say.
yes.
Right.
Pursuant to delimitation exercise, my lord, this is the position. Now, what has happened? The private respondents, my lord, 5 to 10, they issued a requisition, my lord, on 2nd, 2/6/25. Now, that was put to challenge, my lord, before this honorable court. Amongst other various, my lord, grounds were taken. And the honorable court was pleased, my lord, by order dated 12/6, my lord, to stay the requisition, my lord. That order I have annexed, which starts, my lord, from page 81. And the operative part, staying the order.
What is the reason for staying this?
My lord, the reason was the honorable court found that the requirement under 43(2) that was not complied with. Because
43(2). What is
yes,
43?
it has to be addressed to the chairman, giving him an opportunity, my lord, to
Uh-huh.
hold the meeting.
Okay.
Because
They directly
Directly,
send
yes, my lord,
to whom?
to the executive officer, municipal board, my lord.
Okay.
So that was, but my lord, this was one of the ground in the that writ petition. There were other grounds, my lord, and the honorable court, taking into account this ground, had, my lord, stayed the, my lord, requisition. This was on 12, my lord, 6/25. Fixing, my lord, 1/8/25 for further consideration. The returnable date, my lord, it was from page 85, your lordship will find. List the matter again on 1/8/25. Now, what has happened? My lord, at least propriety demanded or the requisitionist, my lord, they ought to have the courtesy, my lord, to await until 1st of August or take a leave from the honorable court, my lord, not to pursue the earlier requisition. But in a hot haste, my lord, what they did on the very next date, 13, my lord, 6, they issued another requisition. If that impugned requisition, your lordship will find at page 87. While the writ petition was pending. Now this rectifying 43, my lord, 2, or rather complying 43(2), my lord, page 87 requisition has been issued on the very next date when the order by this honorable court was passed. And if your lordship comes to the penultimate paragraph, this makes it clear. In fact, we sent a notice of requisition dated 2/6 to the executive officer and deputy commissioner, which were suffering from procedural defect for which we are not pursuing the same. They directly do not withdraw. they are aware, my lord, that the High Court, Honorable Court, my lord, case is pending before this Honorable Court. They do not withdraw. They say, my lord, we do not pursue. And thereby, my lord, they have issued this requisition.
Numbers are requisite numbers?
Numbers requisite because requirement is 3 members.
3.
3.
Addressed to the chairperson.
Chairperson. In terms of 43-2, my lord, this is correct. My lord, my respectful submission is, in the earlier writ petition, there were other grounds which are also incorporated, my lord, in the present, my lord, writ petition, giving rise to the appeal. Those grounds are still pending before the Honorable
What are
Court.
the other grounds?
Other ground is, my lord,
Please, please.
yes, other ground. My lord, firstly, 11(1) requires that the state government has to issue notification with regard to composition of the board. Now, earlier, my lord, there were 14 members, including ex officio members. And your lordship is aware that the ex officio members also have the voting right. Now, when there is a reduction, my lord, in the composition, my lord, so therefore a notification is warranted that presently, my lord, the Lanka board is comprised of 13 members, my lord, including ex officio members. Your lordship may kindly come 11(1) and 11(3), which says, my lord, that the notification is necessary, and 11(3) says, my lord, the MLAs and MPs are ex officio members.
Where is the provision that these ex officio members
Correct, correct.
have a right to
Correct.
vote in a motion of no
Correct,
confidence?
correct.
Where is that?
There is a judgment of this Honorable Court. This has been settled, my lord. It is no more res integra. I place
Is
this,
there any statutory provision here?
my lord.
Is there any statutory provision in the Assam Municipal Act?
My lord, that is discussed in this judgment.
No, I am asking now whether in this act there is any specific provision.
Specific provision, no, my lord.
Hmm?
But,
Okay.
but interpreting, my lord, 11(2) and 3.
Let us see.
I take your lordships directly to paragraph 6, my lord, of the judgment. This is, my lord, 2015 2 GLR 808. Here precisely the case was whether, my lord, the amendment which has come about in 2012 with regard to 28(2), requirement of voting more than, my lord, half of the commissioners will have a retrospective effect or not. While deciding this issue, in paragraph 6, my lord, the Honorable Court has, my lord, expressed that the ex officio members, my lord, would have the voting right. If your lordship permits, I'll read paragraph 6, my lord.
Yes.
Even a cursory look at the amended section 28(2) of the Act will show that any possible doubt on the meaning of number of commissioners who can remove an elected chairman or vice chairman has been removed. Thus, it is more than half of the whole number of commissioners who can now remove an elected chairman or vice chairman. Since the voting right of an ex officio member of the board is not expressly excluded by section 11(3)(b), unlike a member having special knowledge or experience in municipal administration appointed under section 11(2), who has been denied of such voting right, the commissioners contemplated by section 28(2) to remove the chairman or vice chairman shall necessarily include the ex officio member of the board.
Where is the MLA provision?
Yes, 11(3), my lord. Section 11(3). 11(3)(a), my lord. The members of the House of the People and the Legislative Assembly of the State of Assam, representing the constituencies which comprise fully or partly the municipal areas, shall be the ex officio members of the board.
Where is the notification required?
My lord, 11(1). The number of commissioners of each municipal board shall be such as the state government by notification determined in this behalf. My lord, my respectful submission is, now since the composition has changed from 14 to 13, our notification is warranted under 11(1). Otherwise, my lord, this composition has a direct, my lord, relation or effect with regard to, my lord, the voting. Whether the motion has been taken through, whether it is more than half of the commissioners, to determine that aspect, my lord, one has to know the composition of the board, whether it is 13 or 14. If, my lord, the total number is accepted to be 14, then the more than, my lord, half would be different. And if it is accepted to be 13, then it will be different, my lord. So therefore, my lord, these two issues, composition, my lord, and the my lord, if I take your lordships to 28.2, then the issue will become more clear. 28.2. 28.2, my lord, has been subsequently, my lord, it has been amended. I have annexed a notification whereby the requirement is more than, my lord, half of the whole number of commissioners. If your lordship sees 28.2, an elected chairman or vice chairman may be removed from his office by resolution of the board in favor of which here is, my lord, not less than, my lord, but the amendment is more than half of the whole numbers of commissioners shall have given their votes at a meeting specially convened for the purpose. So therefore, to ascertain whether it is more than half, my lord, one has to know the present composition of the board. And that is required to be notified by the state government that presently, pursuant to the delimitation exercise of 23, my lord, the board comprises of 13.
28.2 is very clear. Commissioners, where from these ex officio members come? There may be other decisions also. This decision is regarding this Municipal Act 43.2. Let us see 43.2. Because you have shown me to 28.
28.2, my lord, is the no
28.2.
confidence. No confidence.
Whole number of commission.
My lord.
Where from this ex officio member came?
Because my lord, the observation of the honorable court is if your lordship comes to,
Removing so.
if your lordship comes to 11.2, 11.2 expressly, 11.2 expressly, my lord, restrains or restrict, my lord, the appointed members of the state government. 11.2. And the interpretation of the honorable judge, my lord, is that there is by 11.3
was that 28.2 was discussed anywhere.
This is about 28.2, my lord, because yes, my lord, it's about 28.2.
Where is it?
Yes, my lord, because it is removal of, my lord, chairman.
Sorry, look, will show that.
It is removal of chairman, my lord. If your lordship comes to para 5, para 5, my lord. This is about 28, my lord.
Okay. Okay. So this MLAs and MPs are included. Are included.
Are included, my lord.
They can take part and give
Yes.
vote.
Yes. Now
Yes.
your lordship will kindly see after the changing of the scenario, after the delimitation exercise, my lord, the earlier MP he remains no more. Because presently, my lord, the Kaziranga constituency, it comprises, my lord, the municipal area. Earlier it was the Nagaon constituency, parliamentary constituency. Therefore, the MP has also changed. Now, in terms of 25, the MP has to take oath, my lord, to participate in the meeting. If your lordship comes to 25, there is a requirement of taking oath. The new MP has to come in. The earlier MP goes, my lord. 25, taking of oath. Every person who is elected to be commissioner of the board or who becomes commissioner of the board by virtue of office shall, before taking his seat at a meeting of the board, first attended, make an oath or affirmation of his allegiance to the Union of India in the following form. So there is a requirement of oath also, my lord. Now, if in absence of a clarification, my lord, the proposed special meeting, my lord, in my respectful submission, my lord, will not be in accordance with the provisions of the Act. Anybody can come, my lord, and vote. Who are the eligible and competent, my lord, members to vote?
Yes.
And matter is fixed, my lord. The other matter is fixed on 1st of August, my lord.
Yes, sir, my lord. Nothing I find in the section, my lord.
3 subsection 5.
Which section?
3 subsection 5.
3 subsection.
What? In the persons for the time being appointed or elected to conduct the affairs of any municipality under this act. In that of or regular.
Now 28(2) has been interpreted.
Yes. That I-
This is on the
that-
face of it.
that doesn't know. That does not.
So on the face of it, it is there. They can participate.
So they can participate. One thing.
But, and this 40, but 20,
43 doesn't say except.
oath.
25 months.
25. At least I having been elected or ex officio commission.
Yes.
So he has to,
There is no disciplinary access on that. Because the latest judgment of the, Honorable Justice Devasai Barua has also dealt with that same issue. There is accepted position that MP and MLA,
they have to take oath.
they will have to take over. Suppose, Malik, here, his submission is notification by the government has not been issued yet.
That is not necessary.
That not necessary, not necessary.
Privacy, I am of the view, that is not necessary, but oath is necessary.
But if they do not, in 2023, my lord, there was the delimitation. And during the delimitation, the Nova MP covered that area also. And Ojai LSC MLA covered that area. Since there is no notification, changing this.
Now the area has been, territorial areas have been changed.
But
And that law takes over.
that law, my lord.
I think
No, may not, because unless the government reconstitutes.
then it is a matter to be debated.
And while one more thing. You also kindly see the article 243S. Constitution. Yes,
243
yes.
S.
Constitution and composition ward committee. There shall be constituted ward committees consisting of one or more wards within the territorial area of a municipality having a population more than 3 lakhs. The legislative party may, by law, make provision with respect to the composition and territorial area of the ward commissioners. We will also kindly come to sub-article 3. The member of the municipality representing the ward within the territorial area of the ward committee shall be member of the committee.
Oh, who is the state council? Municipal?
So, my lord, here what I meant.
Other issues are same, otherwise democratic principle has to take over, but
Yes,
question
yes,
is
yes.
that whether the MP or whoever, because if there is change in the territorial area of the municipal board by virtue of the parliamentary law, delimitation act, then at least that person has to take oath as an ex-commissioner, ex-officio commissioner.
Yes.
Who is the state?
But they do
Ah.
not take, my lord. They do not take.
Then composition will matter.
Composition of 11 members. There are
Hmm?
elected directly 11 members. I will revision. When the earlier notification.
Who has gone out? By law, he has gone out. 14 to 13 gone out. No issue. No issue about that.
No, only 11 members.
Prima facie, no issue about that. About only if somebody new member of parliament would be ex officio commissioner or I think council of state is no doubt. No doubt about it. He is everywhere. No doubt about it. But member of parliament
But if he-
and if member of legislative assembly have changed. MLA changed?
Yes. MLA, my lord, there were earlier 2 MLAs. One has out, one is out.
one is.
One
So he is already under oath.
Yes, one is already.
He is already under oath.
MP, my lord, no.
And whether MP
Yes. MP.
is changed.
MP changed.
Yes.
MP changed. It is-
MP changed.
Presently, it is under Kaziranga.
Only that issue.
But he doesn't take what. Now it's more than a year since he's won the election, he doesn't take vote.
Who?
The MP who got elected newly on the
Hmm.
Kaziranga constituency,
Huh.
he has not taken vote till date.
He has not taken oath till, yes.
So he may not take vote at all.
And because it is, this question is in, yes, if he does not take oath, it is a different issue.
Then he will be out.
Then he'll be out.
Then only 12
It is up to him also. Okay, you take your instruction that whether he has become new member of parliament, has taken oath or not. Otherwise,
12
somebody does not want, out,
Yes.
out, he's out. It is his
The
duty.
democratic process and the earlier notice given was withdrawn and new was given. as per
Take
law.
the instruction, we'll keep it in status quo. Thereafter, we'll consider.
Keep your way.
That is no man. Because you also see, the earlier notice given by us as in withdrawn. Then new notice complying to section 43 will be given.
So far as right of the ward commissioners to submit requisition,
Appraise.
FRS, there appears to be no doubt,
No doubt. So.
prima facie. And because everything democratic principle should always be given precedence. Only question is the composition or strength of the municipal board who can take part in the proceedings of a motion for no confidence. That is all. I am only limited to that, nothing further. Democratic principle should always be.
So, my lord. Can it be-
Yes, only thing.
Can it be fixed on 10th, my lord?
10th, no, I don't think so. 14th we can fix.
20 days they record under section 43 2.
Nothing, if something is kept in suspension by the court, that will not prevail. 14th.
14.
Only issue that if he does, whether he has taken oath or not.
Yes,
That's all.
If he has not taken oath, out. We will hold that this composition and strength will determine. Heard.
It will never be stopped.
Heard, Mr. S.K. Talukdar, Learned Counsel for the Appellants, and Mr. S. Borua, Learned Junior Government Advocate Assam for the response number 1, 2, 3, 4. 4. And Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr. For the caveators, stroke, all
5 to 10.
5 to
10.
10. Okay. Post of the a question as arising as what is the composition, stroke strength of Lanka Municipal Board. Post of Mr. It is submitted at the bar that after the delimitation exercise, recent delimitation exercise, the areas of the Lanka Municipal Board has come within the areas of Kaziranga Parliamentary Constituency, post of earlier, the areas of Lanka Municipal Board were within the areas of Nagaon Parliamentary Constituency, post of by virtue of section 11(3) A
Small A.
of the Assam Municipal Act 1956 as amended, the jurisdictional member of parliament is a part of the municipal board in ex officio capacity, post of section 25 of the Municipal Act, for short, requires even an ex officio commissioner to take oath, post of whether the Mr. Borua, Learned State Council has is to obtain instruction whether the after the recent delimitation exercise, the member of parliament from Kaziranga Parliamentary Constituency has taken oath in terms of section 25 of the Act or not. So the instruction is to be placed on 14. Para. Till then, comma, the
13-6, my lord, in requisition, my lord. 13-6-25.
Status quo, my lord.
Ah.
No question of staying.
Ah.
no-
there shall be status quo as regards the process initiated by the requisition
My lord.
dated
13-6, my lord.
13/6/2025 for the motion of no conflict.
Deeply observed.
Then we'll decide.
Well-
Then we'll may go ahead with the
If he doesn't take oath, he's out,
out.
and 12 will remain.
Whatever will remain. That will by law.
He is at liberty, my lord, he can take oath.
Yes, we
We
could
can
not.
direct, not,
we
we
could
can
not-
direct, not.
Yes.
not the government
He can take oath, my lord.
Within
Uh-huh.
weeks. He may not take oath.
No, it is up to him.
Yes, up to him, my lord.
It is 2
Deeply
years
observed.
since he has won, my lord. he's
Deeply
gone.
observed.
Yes, Mr. S.B. Loskar.
My lord, my lord,
Is it very important?
yes, my lord. My petition will become infructuous, my lord. Only one point, my lordship.
Because
If the regulation is violated, my lordship, then we have a case. If the Assam Land Revenue Regulation, my lordship, if it is violated, then we have a case because my lordship, rule of law has to be maintained. My lord, kindly see the impugned notice on page 69, my lordship. Page 69, individual notices has been issued. I have annexed one of such notices, my lordship. We are staying in a BGR land, my lordship.
yes, Mr. বৰপূজাৰী অন্যথা প্ৰশাসনৰ তৰফৰ পৰা আইনী প্ৰক্ৰিয়াৰে বিহিত ব্যৱস্থা লোৱা হ'ব. Would you follow all this? This is a বেদখল মুক্ত, you know, so and so. This is a notice.
Say nothing.
Therefore, what is the process?
Rule 18.
They don't look to because the.
বিহিত ব্যৱস্থা.
Because of the study of it. Eviction will follow. Because
Hmm?
admittedly,
The ranger
No,
cannot
no,
issue. my
বেদখল
lordship.
মুক্ত, this is notice.
it's-
So you had a right to respond or not?
No, my lordship. We did
Huh?
have
Where
a
is
right.
that?
And the ranger cannot issue such
Salakuddin
notice.
will not come here because this is a PCI land and Salakuddin has not interfered with PCI land. Right? It is only applicable to government first land.
Rule 18 may be seen, my lordship. Rule 18 of the.
Rule 18(2).
Yes. between.
What has been interpreted by Salahuddin? Otherwise, Jagpal Singh is always there.
That.
Always there.
My lordship, that's.
Salahuddin will not prevail over Jagpal.
My lordship, in that case also, my lordship, principle of natural justice, my lordship. In this case, my lord, Jagpal Singh, last para may be seen, my lordship. The seed scheme should provide for speedy eviction of such illegal after giving him a show cause notice and brief hearing.
Hmm?
Para 22 may be seen, my lordship.
Jagpal,
Yes, my lordship. Para 22.
please.
My lordship. Before parting with this case, we give direction to all the state respondents in the country that they should prepare scheme for eviction of illegal unauthorized occupants of Gram Sabha, Gram Panchayat, Param, and Samlat land.
Which para?
Para 22, my lordship. Para 22. Jagpal Singh and others was the state of Punjab. For this purpose, the chief secretaries of all the state union territories in India are directed to do the needful, taking the help of other senior officers of the government. The said scheme should provide.
Yes, Mr. Borpuzari.
Regularize, because he has not read the complete paragraph.
My lord.
Only see, my lord.
Stop.
The said scheme would, the same scheme should provide for speedy eviction of such illegal occupant after giving him a show cause notice and a brief hearing. Long duration of such illegal occupation or huge expenditure in making construction thereon or political connections must not be treated as a justification for condoning this illegal act or for regularizing the illegal possession.
No, we are not on regularizing illegal possession.
Also in my.
What was that word? Brief hearing. You give hearing. Small hearing, whatever.
And my lordship, So 18(2) specifically says ranger does not have jurisdiction.
Huh?
Ranger, forest ranger, my lord. Impugn notice has been issued by by forest ranger. Land policy 2019, my lordship.
If I have Mr. Loskar, Mr. If I have seen page 70, then I'll don't make wrong submission.
No, deputy commissioner, I sorry, my lordship.
Deputy Commissioner can have.
Yes,
Chokro Bikhoya, circle officer,
Circle
he
officer.
has the power.
my lordship.
Notification is there.
Yes, my lord. Deputy commissioner has the power, my lordship. But this impugn notice has been issued by circle officer, my lordship.
Okay. He has the power.
That's the power.
Okay, you give a hearing within 15 days. Give a hearing as per Jagpal. You
Yes,
submit whatever is
My lordship,
available
and
at your disposal.
my
At
lordship.
your disposal, whatever you have. At your disposal, documentary
Yes,
evidence.
my
You
lord.
place it.
Yes,
for
my
a
lordship.
circle
We have
officer.
NRC 2019.
No, we are not
51,
into.
my lordship.
We are not looking into it.
My lordship.
I think.
We'll
Please,
submit
please.
documents. We'll submit documents.
As per Jagpal, because the impugn order. Brief hearing.
I go by it, but principal kindly admits it, please report it on I should quote it, it's an interim order, that in petition is always there, it is available. It is still
But
there.
because it has been declined,
Therefore,
so it should be with modified. Only to that extent that before acting on the notices, that the notices should be given a hearing in terms of Jagpal.
Yes,
That's all.
Yes, sir.
yes.
Heard Mr. S.B. Loskar, learned counsel for the appellants, and Mr. R. Borpuzari, learned standing counsel, revenue and disaster management department for the respondent number 1.
Well, I am for one.
One, Ms. R.V. Bora, learned junior government advocate, Assam, for the respondent number 2, 3, and 4. Full stop. And the appellants agree by an order, interim order dated 25/6/2025, passed by the Learned Single Judge in petition WPC number 3669/2025, preferred by them. The appellants are in this. Appellants have preferred the instant intra-court appeal. Full stop. The gist of the contentions, advanced by the counsel for the appellants, in brief, they have been served with notices for eviction. All dated to 6/2025.
Yes, my lord.
Yes, I next only one.
All,
Okay.
Take it to me.
Notices, all dated to 2/6/2025. Whereby they have been asked to vacate a plot of land covered by government DAG number 149, which is shown to be PGR land. First up, the notices have been issued by the jurisdictional circle officer. First up, when the notices in a repetition command, the appellants petitioners have assailed those notices. First up, the learned single judge has declined to pass any order any interim order, has declined to extend any interim leave to the appellants. As the lands and as the concerned land in the notices concerned land is described as VGR land. And in view of the settled position law as regards VGR land, in the light of the observations made by the Honorable Supreme Court in Jakpal Singh and others versus State of Punjab and others, 2011, 11 SSA 396. Full stop. This para, I don't know, in Jakpal Singh, Supla.
Paragraph 22.
No, paragraph 22, problem is that this is Indian canon. FCC will be different. Right. Silo 22. In paragraph 22 of Jakpal Singh Supra, comma, while envisaging speedy eviction of illegal occupants from VGR land, comma, the process should involve issuance of a so-called notice and a brief hearing to the noticing. Post of. As the appellants hearing have contended that after the notices, comma, dated 2/6/2025, comma, in the notices, comma, dated 2/6/2025, comma, there is no indication of any hearing, comma, no indication of any hearing, full stop. In view of in the light of the observations made in Jakpal Singh Supra, for giving a brief hearing to the persons who are found to be in illegal occupation of VGR land, comma, we are of the considered view that the jurisdictional circle officer, before proceeding further, should give a hearing to the notices who have been served with the notices dated 2/6/2025. Post of such an exercise is to be completed as expeditiously as possible, comma, within an outer limit of, you take it,
30 days from today.
30 days from today. When is the next date? 6 weeks. That one.
6
weeks. Sorry, with the interim, the impugn order dated 2/25/6/2025 stands modified to that extent. Also, the reticle is disposed.
The next date as per this notice is 3/7, so they will have time. And your lordship will kindly.
The issue notice returnable in 6 weeks, single judge has said. So I think within that time, it will be there.
Actually, we are relying on rehabilitation. We are not claiming any land. Because we are landless.
Don't change now.
We are landless persons, my son.
List is misplaced. Digboi carbon and carbon resources both are given separately. This is Digboy. Having examined the impugn order dated 19/9/2022 from all legal standpoints, the clear view this court has reached is that the impugn order dated 19/9/2022 cannot stand the scrutiny of law. Correct petition is allowed.
Item 16 to 21. 16 to 23 others.
For the observations made, the regions assigned and the findings reached that as above, the orders dated 7/11/2022 passed by the respondent number 2 and as sealed in this batch of six petitions have been found to be unsustainable law as the decision is based on clear ignorance and disregard of the provision of law which is manifest error right in the case of the proceedings. Are therefore liable to be set aside. Finally, set aside. A direction is called for directing the respondent authorities to process the petitioner's claim for reimbursement of the value-added tax paid on raw petroleum coke purchased within the state of Assam. Yes, bail petitions are yes.
May I please, Your Lordship, with respect to item number 4.
Or
Lordship,
yes.
This criminal petition is arising out of several matrimonial disputes.
Hmm.
And in some of the disputes, it has been remanded to mediation. And also the talk of settlement has been going on. So, Lordship, may I pray for listing of this matter after summer vacation?
Okay. Mr. Item number 4,
Four,
Rinku
Lord.
Kumar Pegu.
Lordship.
Okay. Mr. K. joined learned counsel for the petitioner and sought listing of the case originated immediately after the ensuing summer vacation. Ms. P. S. H. Boral, and Eviction Public Prosecutor for the respondent number 1, State of Assam, is present. So, as prayed for, raise the case originated immediately after this ensuing.
Much
summer
obliged.
For Muson AB, item number
AB.
22.
Maybe.
Just a minute, just a minute. Yes. Yes, FIR,
Fair will not kindly see page 9, which starts. And
page 9.
The 11 portion, I have translated copy place 12 and particular that is
Who are the petitioners?
page petitioners are 4.
Four
One is
petitioners.
husband, second is husband, brother, 3 and 4 they are father and mother.
Okay, let us see the FIR.
Affair particular page 16 and translated copy page
16.
12. Yes.
It was Benito Nivenel.
Long
It was
back.
initially complained or what?
Yes, it was initially a complaint case, then it was forwarded to the OC, then it was now, yes.
When the marriage?
Marriage about in 2012.
12.
12.
Have
Now,
you stated so?
yes,
In the writ petition? Oh, sorry,
Yes,
in
sir.
the
I have
body of the
explained
petition.
and their first child is about 9 years. Sorry, 11 years. And second son 5 years. They are in India's army.
14 years ago.
Well, and now,
1 minute, 1 minute. I am not right.
But one thing that earlier also there are some issues in page 17, second paragraph. That was compromised. Something was happened, but that was
The minute.
page 17 also.
Here daughter Milord, Saniana Parveen, aged about
Who is accused number two?
brothers, husband, brother Milord. Young for father, mother. And there is no one Milord, he is the husband. And only one thing may I submit, Milord, that there is no any single word against the father and mother Milord. Nowhere.
Hmm.
The complaint case was earlier initially, then it was forwarded to the OC.
What are these offenses? 118, all this. I can't actually obedience को की उसी को नहीं.
Make
So
voluntarily without
I'm not very familiar with BNS.
voluntarily causing harm, previous harm.
108, 18.
118
Said 18. Causing heart. 85.
85 Milord, husband.
85.
Husband or his relative Milord
But
causing.
it is 498A.
Well, yes, exactly. Now.
Okay. 62.
62 attempt to commit offense Milord.
Them to commit a
And
64.
64 2 Milord. Rap by, actually it is not in this case applicable. This I don't know how it is. Rap by pollution might do I have seen I have heard this section. At 109.
351.
But it talks about against number 1 and 2,
Specifically two. Not specifically to the husband. After 14 years demand of dowry. 1, 3 and 4. Hard. 1, 3 and 4. Hard. Mr. A. Rashid, Learned Counsel Board. Petitioners and Mr. KK for our Learned Additional Public Prosecutor for the state. Post of. What is the provision nowadays? 438 or 38 low BNSS. Huh?
481.
Kokraza Police Station, case number 141, 2025. For offenses legally available. Huh? Mr. Rosid, Learning Counsel for the petitioners has submitted that the marriage between the informant and petition number 1 was solemnized 14 years earlier, and there are no specific allegations in the FIR, which was filed as a complaint earlier, against the petition number 2 and 3 and the petition number 4, who are the father-in-law and the mother-in-law of the informant. He has further submitted that apart from some vague allegations against the petition number 2, that is the brother-in-law of the informant, an allegation is also made. Allegations are also made against the petition number 1, that is the husband, regarding demand of dowry. He has submitted that the allegation of demand of dowry after 14 years of marriage cannot be comprehended. List the case on 22nd July. The National Public Prosecutor shall produce the concerned case diary on the next date of listing. First of having regard to the allegations made in the FIR against each of the petitioners and the ingredients of the offenses under which the FIR has been registered. This court is of the premise view that there are no specific allegations against the petition number 3 and the petition number 4. Insofar as the petition number 1 is concerned, the allegations appears to be general in nature. Having Very good. In view of the scene, and it is provided in the hearing. Allowed to go on 1, 3, 4. How much? 20. 1 surety. Appear within before IO. 10 days. Baki, directly, indirectly, in part and part.
23. FIR is
FIR,
page 14, my.
page 14. Kafiruddin Hajari. Sahabuddin Hajari. Any relation?
Yes, brother, own brother.
Own brother.
Own brother.
Okay, I will like
There
to
is a
tell you
land
that
dispute, my lord.
I have received an eviction notice in connection with DRPC. What is DRPC? Okay, Debt Recovery Tribunal. So notice appears I stood as a guarantor for a loan taken by my Sahabuddin Hajari. So from Indian Bank. I need to get the money on inquiry. When I say making I have to get loan money, getting mortgage over my bank, signing document. With me, man. There is no photo of mine in the bank account. Documentary. Hard, Mr. Huh? Okay, providing interim. Hard, Mr. J. Amit, Learning Council for the petitioner. And Mr. Kiki Porhar, Learning Tradition Public Prosecutor for the state post of 482 BNS, huh? I got 432 trade. Silchar Police Station case number 960 2022, registered under section 420. Yes. 420 IPC. Okay. The allegations in brief in the FIR lodged against the petitioner by his brother is to the effect that the petitioner, while obtaining a loan from the Indian bank, had fraudulently mortgaged landed property of his brother, that is the informant. Post op. The informant has alleged that he did not sign any document to create mortgage over his own landed property on behalf of the for obtaining loan by the petitioner. Post op. That is Eric 24. Having regard to the allegations made in the affair, it as appears that the allegation is based on documentary evidence. It is before it is sorry. Having considered same I am considered view that till production of the case very interim protection can be extended to the petition. It is therefore provided in the interim 25,000 1 COT before the IO 10 days.
That's 24.
FIR
Lordship affairs by page 11 also. May I read, Lordship?
1 minute. 11.
Yes.
15. Return to Rati Putra Puari. And Mokban Purpura, teacher night. Rahulamin, story with a Kamalam Rami tourism. And Equimura Mitulu, the Mulmaris, Chula, Mitulu, Palabili of Ratagan. And reporting her very Yes.
Assaulted three ladies,
Huh?
all are ladies. Who have been assaulted.
Ripuara so Monjuara. Ek nong Asami.
No, no, Assami, similar, the victims all are ladies, one ladies. My mother and two sisters.
13. My daughter-in-law informed me from my door that my son,
Lordship, may,
Rahul Amin's will become defendant. Page 13. Page 13 is the FIR.
no, 11, Lordship.
Huh?
There is-
11.
Yes, Lordship. There is two FIR, Lordship. This FIR, the present FIR is a counter blast of another FIR, Lordship.
11.
Yes, Lordship. The page
Due
11.
respect,
Yes,
that's on 29/5. My younger sister's husband. Younger sister husband. My mother, sister, father went to the disease. Secret knowing of another. When
Five copies, page 9.
Lordship, may I read?
On what are the offenses? 126, what is that?
Lordship, section 126, 2 is the 341 of IPC, Lordship. All available.
126.
Yes,
Wrongful arresting, okay.
yes, Lordship.
117, wrongful confinement.
Yes, Lordship.
What is 74?
Lordship 74 is 354A, Lordship. That is the assault or use of criminal force.
Criminal force.
Yes, Lordship.
And what is 35?
35 is 34 IPC, Lordship. Common intention.
34.
Yes, Lordship. 34. So, Lordship, all are available section, Lordship. Only 74 is there. That is unavailable.
74.
And the
74
punishment
is equivalent to 354
354A, Lordship.
A.
And punishment is less than 5 years, Lordship. And what happened, Lordship? This is the counter blast of another affair, Lordship. Here the petitioner is the cousin brother of Rahul Amin, Lordship, who is the brother-in-law of the informant of this affair, Lordship. And he
R. Mr.
R. Islam, Lordship.
R. Islam and Council for the Petitions. And Mr. K.K. Porhol and Additional Public Prosecutor, Petitioner. And Mr. K.K. Porhol and Additional Public Prosecutor for a state. This is an application under 482, 438 or type BNSS 2023. As I posted in the book, said whatever police station case number in the section, so it's like in the
Paragraph 5.
FIR.
Yes.
Lodged by the informant on 26/2025, an incident allegedly occurred on 29/5/2025 has been reported, naming the petitioner as one of the accused. One, Rahul Amin. Was the brother-in-law of the informant. When the informant's near relations went to the house of Rahul Amin, they were allegedly assaulted by the accused persons. And as a result, no, post up. 24/7. Inland edition producer. The concerned case there on the next date of listing. Having regard to the nature of allegations made in the effect. More particularly, against the petition, is provided in the entry. 25,001 security. 10 days before the IO, tempered, directly, indirectly.
E25.
Please. FI is at page 48, last page.
Case 48.
Last page.
Why so big,
Lordship,
bulky?
Lordship, this
Huh?
case is connected to another case also.
Who is the petitioner? What is the petitioner's name?
Leela
Lal
Guru.
Bahadur.
Leela Bahadur Guru.
Leela Bahadur, I will state that connection with goats have been seized. Seen before us, so there is sufficient space and manpower from the seizure have submitted everybody. Honorable Court for passing in order for any the seized of Petition, Foundation Ganga, Ushala, Kavi, Pathar. According to Honorable Court, have passed on the handing over the same to Tian, Foundation Ganga, Gozula, Kavi, Pathar. And over the seas, both to supervisor. Leela Guru Dhilan Founder Jimna order. Later on, I was ordered to hand over the seized 38. First to each owner from Mumbai. Surprisingly, I got said in all of that. So at your hands, goats died.
Lots of the goats were kept in Dhyan Foundation also. See, he is the person who received. But on the very first day, lots on 27/11, when it was received, the goats were infected, lots. That was acknowledged by the police also, lots. I have annexed the medical certificate also.
Where is that?
Medical certificate at page 29 also. Lots will find the relevant portion also.
What is this?
This is a medical health certificate of the goats, lots.
Ah.
At page 34, lots. Original, I have also annexed, lots.
29, I think those are alive, perhaps.
On that day, those were alive, but infections were there. Lots. That was acknowledged by the police also.
Where?
Page 38, lots. Page 38 is the original. Type copy is the 34, lots.
Page 38.
38 is the original version also. That the person, the police personnel who came.
No, that is a Jima Nama 39.
Yes, lots. But no, lots. 38. 38.
38 is what?
38, this is the acknowledgement by the police that some infections were there with the goats. And the infection with the goats.
What?
PPR infection. It was acknowledged by 3 of the goats out of the 39 goats that were infected, and we refused to keep that. But as per the order of the court, we had to receive that. And the present petitioner also he acknowledged the Zimanama. So thereafter also we could not resist the infection also. We informed the.
Did you report?
We report to the veterinary doctor also.
Where?
It is page 43 onwards also.
43 or not?
Yes. This is a 43, 44 is a type copy. Originals are there. On 21, 20/01/25 we report, and on 21/1 the votes has been given to the Zimma of Amir Hussain, who is in fact the accused in the original case.
So page 43B.
Yes, yes. These are the originals. Type copy I have given. 43A is the type copy.
This means that died.
Died, yes.
So some plague.
No postmortem report is there, otherwise.
We requested for the postmortem, but there were some communications also, I could not annex that.
But there is a signature at least.
Yes, no, sir.
Veterinary officer.
Yeah, veterinary officer signature.
State Veterinary Hospital, Halem.
Yes, no, sir.
Page 44. Please. And in case of plague or something, let me die at one go. Mr. D. Das, learned counsel for the petitioners. And Mr. K.K. Parhal, the additional public prosecutor for the state. First of 482 BNS, apprehending his arrest in connection with church to Harlem Police Station. The FIR was lodged by a sub-inspector of police, Vishwanath Police Station on 10/2/2025, alleging that 39 number of goods handed over to the petitioner. And as what? Supervisor,
No, he's the staff
supervisor,
caretaker.
Messrs. Dhyan Foundation, Ganga Gosala.
Lots.
Was that which date?
But so it was handed over on 27/11.
27/11/2025. Post of the
24.
goods were seized in connection with Vishwanath Sareli Police Station, case number 208/2024. Post of in the affair, the informant had realized that when he visited Ganga Gosala on 1/2/2025, all 39 goods were reported to be dead due to plague-like disease. Post of para. It is contended on behalf of the petitioner that due to rapid spread of plague in the interregnum, all the goods died, and the matter was reported to the veterinary officer by later by on
On
page 44.
20/01/25. On 20/01/25.
28
20/01/25.
and the said fact. Sorry, by later it is 20/01/2025 by the competent authority in Ganga Gosala, and the said fact is known to the veterinary officer, State Veterinary Hospital, Harlem. Also, he has referred the land counterpart of petition has referred to annex to the letter, which is annexed at annex 8 at page 43B. Closed. This is the case on so and so. Case diary. As the debt, as the information regarding debt of the goods handed over to Ganga Gosala due to plague like disease was reported to the jurisdictional veterinary authority by Ganga Gosala on 20/01/2025. As Nalagar, post of having regard to the aforesaid positions, it is observed in the intent that spends 25,000 on COD 10 days IO. When 24/7.
In 10 days also. In 10 days also.
10 days.
Item 26. 26 is also out of the same file also. She is the one who has communicated to the veterinary officer also. That's why she is being searched.
Same.
What's? I'm
Delayed is for motion. I don't know one.
My lord, may kindly peruse the order dated, last order, my lord, 19th of June. Some instruction were sought for regarding the
Instruction.
Instruction will receive, my lord, most of the pictures are found in the border book here, my lord.
We'll give consideration after vacation then. We'll just record that.
In that matter, may I pay for issuing notice? And actually status was
We
called.
don't have any time today, Mr. Nath. Be reasonable also. Whatever cases are there to give consideration, we'll give consideration. Why you are aggrieved?
My lord, originally FIR was lodged in All Women Police Station. And thereafter, accused was arrested. And thereafter, my lord, without knowing to the accused, informant, the case was subsequently transferred to, as reported by the
Who has reported?
All Women Police Station.
Now they are saying
But the thing is that the status was called
pertaining to so-and-so Bodarpur.
since 2009, now that case only 2019. So status was called from the All Women Police Station. My lord.
Okay, in
Whether
the
they-
meantime, you find out from All Police Station, get the instruction. Heard Mr. DK, Natural and Council for a petition, and Mr. KK for a hold and direction, public prosecutor for the respondent number 1 from the state of Assam. Post of Mr. Farahar has placed a letter dated 23/6/2025 from the officer in charge Bodarpur Police Station as regards the matter of transfer of All Women Police Station case number 163/2019 post of as per the report, no record pertaining to All Women Police Station case number 163/2019 is found available at Bodarpur Police Station post of Para. The Lieutenant Additional Public Prosecutor shall obtain a status report as regards All Women Police Station case number 163/2019 from the officer in charge All Women Police Station on the next date of listing. Place the case on. Yes, when?
Soon after the 16.
16.
Okay. Item 2. 163 of 2019.
No, 160/2019.
Lordship, matter may be passed over for time.
No timing today, madam. On the
Lordship, my
request of
receipt
Miss,
appear.
we hardly have 15 minutes time. He may not come. Place the case on 15 on the prayer of the land transport application.
Item 3.
Complex.
That is earliest.
Kindly taken the after matter after petition.
After vacating. Good submission. On the prayer of Miss Nim
Monica Das.
Monica Das, lays the case on 16.
Item 5.
Matter is a lordship. Matter the instant matter for the quashing, my lord. The merely to pay the agreed amount, my lord. If
Only notice we can do, we hardly have any time to apply our mind.
Yes,
Or
ma'am.
otherwise after vacation.
But legal work on the 16th of July fixed, my lord, for appearance, my lord. 16th of
14 then?
Yes, my lord.
Okay, 14. PK Deka, Learned Counsel for a petition and Miss S.H. Paul, Learned Additional Public Prosecutor for the respondent state is our present. Post of as sought for, this the case on 14.
My lord, deeply obliged.
Number 6.
Lordship, quashing proceedings.
Passing,
Lordship.
if
Quashing
don't
of
have time to
ticket.
apply mind, you might have interim prayer also.
Yes, Lordship.
Then we need hardly have any time.
Only thing, multiple proceedings are going on between the parties. And
Okay, when is the next date?
24th of July.
Then before that, 16, B Bhagavati. This reference is there, otherwise
Yes, Lordship.
SH Bora, otherwise I would have said And there is no possibility to sit thereafter. SS Bora, 16. So,
I don't know, 7. Yeah, no, so, my lord, quashing of proceeding, my lord, petition. My lord.
Crossing of proceeding.
The matter.
What, FIR against you?
My
You
lord-
are on bail.
Yes,
bail.
my lord. Yes, my lord. My lord,
then-
regarding, my lord, regarding this,
Come after
Search and-
vacation.
search and-
Will not make any observation.
Right.
Come after vacation.
totally civil nature, my lord.
Okay, we'll see. 16.
Yes.
T6. Yes, Bora. 16. Extreme emergency, we can do.
May I please, your Lordship? Lordship, civil dispute given a criminal color, Lordship.
Hmm.
Simple case, Lordship.
Any bail?
Lordship, quashing, Lordship.
No, bail already granted.
Lordship, it's a complaint case.
Complaint case.
Yes, Lordship. The case is fixed on 10 of 10/7.
10-7.
Yes. Lordship, 14 lakhs was taken as a loan. That was not repaid and 420 cases filed as a complaint case.
Complaint case.
Lordship.
Yes, madam.
Lordship, it's a private complaint.
Private.
State is not a party.
Okay. Heard Mr. Bora, Learned Counsel Bora petition. Post of by instance. Petition under 428 Bharatiya Nagarik Puratham Act 2023 is preferred seeking setting aside of the proceedings of complaint case number 29/2024 presently pending before the Court of Learned Judicial Magistrate First Class number 1 Karbi Anglong at Bifu. Post of the petitioner has also assailed an order dated 19/6/2025. Where is that?
At page 61.
61,
Yes, Lordship.
whereby the Learned Trial Court has taken cognizance on the complaint issued process against the petitioner as the sole accused,
Sole accused.
Post of para. The complaint petition is annexed as annexer 1 to the criminal petition. Post of the gist of the allegation in the complaint is that the petitioner borrowed an amount of rupees 14 lakhs. Post of. Insofar as the petitioner had executed an agreement with the complainant for an amount of rupees 5 lakh. Post of. However, for the remaining sum of rupees 9 lakh, no agreement was executed between them. Post of. It was the allegation of the complainant that the petitioner had allegedly endeavored to hand over a plot of land against rupees 9 lakh. But due to the manner in which the petitioner sought to hand over the plot of land was unauthorized in law. But having regard to the nature of allegations made in the affidavit, privacy, the ingredients of the offense, and the
420, Lordship.
Or the offense defined under section 420.
Now it is 318 within bracket 4
318.
of BNS.
318
Within bracket 4 of BNS.
4 BNS are found to be not present. Question. Issue notice returnable. I think title issue notices returnable in 4 weeks. The petitioner shall take steps of service of notice upon the respondent by registered post utility mistakenly. It is observed in the interim that the further proceedings of complaint case number so and so presently pending before the court of so and so shall remain suspended till the return.
All right, Lordship. Lordship has observed 428 application. It will be 528 application.
520.
All right.
All this to silent. Was silent.
Take up after vacation, my lord.
G. Alam, A. Begum.
15th, my lord, or 17th.
16? 18? 18?
18, my lord.
18.
Obliged.
Not possible.
Item 12, my lord. There's a connected matter which is fixed on 21st, my lord.
21st.
21st with BA number 2055 of 25. my lord.
Item
12, my lord.
12. Okay, very reasonable submission. Mr. S. Nawaz, Learned Counsel for the petition has submitted that another petition comes involving similar issues.
Same issue.
Involving similar issues, is ordered to be listed on
21/7, my lord.
21/7/2025. What is the given petition?
That BA, my lord. BA number
B.
2055 of 25.
B, huh? Here's short listing of this petition on 21/7/2025. This given petition on accordingly on so and so with BA number so and so.
May it please the lordship.
Item 11, Act statement of 15th of July.
14 then. Okay, Mr. Here we Learned Counsel for a petition has short listing of this recommended petition on 14th. List the case accordingly on 14th.
Yes, item 14, the last item, while my matter is fixed on 7th.
What to do?
7, my lord.
No, you are against what?
Assailing a FIR, assailing an offense report, a cognizance report, assailing a charge sheet also.
Oh, SARS it also.
Yes, madam.
You take an adjournment there.
No,
Take an
but-
adjournment.
If time it will take, they will take care of my item.
Okay. Due to Mr. D. Gugoi, Learned Counsel for the petitioner is present, due to early rising of this court at 2:45 p.m. today, the case could not be taken up. First up, lays the case accordingly on 14 or then 16.
16.
May it please the lordship. Item number 30, my lord. I'm just praying for issuance of notice, my lord. There is no stay. Item number 13, there's only issuance of notice. I am challenging the order under 174(3) where my FI was not registered. And I have a complaint. However, the order passed by the learned single.
Okay. SP Sharma, Learned Counsel for the petitioner. Right, and Mr. Oh, 1 minute, 1 minute. I'm passing the order. I thought that you were public prosecutor.
Yes, state.
A. Bogom, Learned Additional Public Prosecutor for the respondent. Oh, no, nobody is there. State is there or not?
There's a private respondent, my lord.
State is there.
Yes, state is there, my lord.
1 and 2. 1 to 3.
Yes, ma'am.
CID?
CID is also there.
Okay. Agree by what?
One of the
CID? You are CID? CID? Where is the impugn order?
My lord, the impugn order is at page 76, my lord.
Agree by an order dated 6/6/2025 passed by the Court of Learned Chief Judicial Magistrate Kamrup Metro in CR case number 204C/2025, whereby the Learned Court has dismissed
Page 77.
dismissed the petitioner's petition number 2753, filed by the petitioner, as not maintainable.
In CR case number 204.
Huh? I have already said 204C is Lutheran Bengal. Agree by likhna na? The instant criminal petition is preferred. Issue notice returnable in courts.
Much.
Steps, extra copy
My lordship.
as appeared and so and so and so.
May I please, Lordship? Lordship, writing number 27, otherwise Lordship has upheld matter that 148 section 1.
Did you brought?
Lordship, I prepared the.
I gave you the opportunity to make a mention.
So.
No, I said you make a statement in an additional affidavit.
Lordship, I will do that also, Lordship.
Mr. Mehdi, I have given you enough indication that you are in incarceration since so and so. Make a statement on oath.
Lordship.
I did not ask you to get a copy from.
I thought, Lordship.
I yesterday myself indicated to the court master that when he makes a mention, bring it on record. I have given you enough time. 2 days I have given you. Day before yesterday. I am not a tutor here.
Lordship, I will file the additional along with the.
Make a mention before the court, vacation court.
Lordship.